On this very, very cold winter's morning. And thank you for joining us. I think that we have a full 3 hours ahead of us, a very interesting 3 hours ahead of us. And it's something that we've been asking for a very long time now. So I want to say thank you to Janusz for accepting our invitation to enlightening us this morning. You know, we think that we work with the legislation and the regulations and that we should actually have it under the belt. But I think that, you know, it's important to be able to understand where we are actually falling short, where our shortcomings are. And I think very recently, some of the industry members have been requesting quite fervently clarification. Distributed Janusz. Janusz is an attorney working at Hahn Hahn, and his reputation precedes him, I must say. And I think most of you will know him. Most of you have probably been at some of his presentations. But Janusz has been working closely on these regulations with the government for, you know, in the inception of these regulations, and also has presented several of these lectures or several of these workshops. Today, of course, his specialty is food law. And again, I want to say thank you to Janusz for accepting our presentation.
Good morning. I almost had a technical glitch there. I reached over to touch something, and nowadays all these things are touch sensitive, and it turned off the camera. Sorry, I had to restart it. Okay. Good morning, everybody.
Before we go any further, Janusz and Deirdre, I just wanted to share with the attendees the way this works. So firstly, you would only be able to see either Janusz, Deirdre, or myself, because we are then the panelists. And we cannot see you, but we obviously see who has been able to join. So if you are trying to get a message across to any one of us, I urge you to use the chat that you will find at the bottom of your screen. And if there's anything very urgent in the midst of the presentation, please raise your hand. It sounds like classroom, but please raise your hand and please ask your question, and we'll try and resolve as quickly as possible. We have allocated a full hour for questions and answers, but also you'll see throughout the presentation that Janusz has included the questions that you've pre-submitted to him, and we are dealing with the questions as we need to. We did try to separate the accessory company section with the formula company section versus the INASA section, but one feeds into the other, and we found that it's, you know, you're welcome to come and go as you'd like, but we are setting the stage for the full 2.5 hours that we are hoping to cover. So my consideration to you, or my urge to you, is to stay the duration. It's going to be worthwhile, I promise you. Yeah, we should be done hopefully by around 1 o'clock, if not earlier, and that's with the question and answer session. So again, welcome everybody, and Janusz, we hand over to you.
Thank you very much. If I can just say, if there are any questions, Nazneen, if you see the questions, because I'm in full screen mode, I won't see the chat. Then I think you will need to interrupt me by speaking so that we have a question, if there is one that you feel needs to be dealt with there and then. But as I said, ideally, the questions that were sent in appear at the section right at the end of the presentation before the, let's call it, open questions. And maybe we should leave it to there because of the environment we're in. If I was on a stage in front of people, I would in fact encourage people to interrupt me at any time. But the difficulty with these types of presentations is one can lose track of what's happening. Okay, so thank you very much for inviting me to present this to you. I'm looking at the camera right now so that you can see me, but while I'm presenting, I'm actually going to be turned at an angle to you because I'm using a conferencing camera, which isn't part of my computer, so it's slightly to the left of me. I hope you don't find that too disconcerting. Okay, so today we're going to be speaking about infant food and FSMPs and the regulatory environment. Now, these are all really difficult topics because that's all not really well handled in our law. There's obviously some degree of interpretation, and I think the reason you've asked me here is because you're having difficulties with the way that the regulators are in fact interpreting this. So let's start off by discussing the regulatory framework. And what we have is that you have acts, which are, let's call them the laws, and we need to discuss what is their place in the regulatory framework. We have regulations, and we need to understand what is their place in the regulatory framework. We then have the dreaded guidelines, which DOH seems to like to use not only in this context, but in other contexts as well. And what is their place in a regulatory framework? Then we have other things which are not obviously always thought of, such as the Advertising Regulatory Board, the ARB, and other aspects of self-regulation. And I thought it's important to discuss that as well, because it does impact in this field. Then we've got constitutions of societies, by the way, such as, for example, the IFA. If you go on your website, you've got a constitution. You've got policies. There's UNICEF guidance documents. What do they mean, etc. And then finally, the overall umbrella, which is the constitutional right to free speech. And this does come up as a question as to how can government tell me what I can and can't say to the public. Possibly this question has become a bit moot now that we're sitting in the midst of a lockdown and we realize that you can buy shoes but not socks and things like this, and the government can pass all these strange regulations in the public interest, and we will deal with that. So that's going to be the overall sort of approach of today, is how do all of these things fit together? So let's start off with the regulatory framework, and right at the top of the pyramid we have the acts. Sometimes people will call that the laws. And we need to, what's really important to understand the process is, how does an act come about? Because if one understands how an act comes about, maybe you can understand the importance and the hierarchy of each. So when the government wants to write a new law, pass a new act, they typically publish a green paper, which is their sort of pie in the sky, wide ideas of where they want to go in terms of policy. From that, you will have a white paper, which is then published for public comment, and the public gets to comment, and sometimes there are several iterations of the white paper. Eventually, you get the draft act. The draft act again will be published sometimes more than once for comment, and eventually it goes before parliamentary committees. I myself have presented to these committees. They will invite industry, they will invite the public, they will invite all sorts of people, academia, and you will then go before the parliamentary committees and present your concerns about the draft bill. At that stage, it's a bill, about the bill and what it intends to do. And then once you have left, the committee will then vote, or sometimes just decide by consensus, what changes need to be made to the bill. And finally, the bill goes to the president, and it's assented to by the president. And finally, it gets proclaimed as an act. So as you can see, it's a very intensive process. There's a lot of consultation. And what I need to say, it's very important. The fact that your comments aren't included in the final act doesn't make it invalid, or they didn't consider your comments. I can consider your comments and believe that they don't comply with our policy. That doesn't mean that I didn't allow you to comment and consider your comment. And not just in this context, but in various contexts. And I suppose today, in the COVID environment we're living in, and the debates around tobacco sales and alcohol sales, where they asked for comments, and some people commented for it, some people commented against it, but you can't be for and against it. So at some point, government must take a stand. They either go this way or they go that way. And this is where acts then come about. They define the law, the framework of the law, and they are what they are. They've been through a process. And very importantly, what I've highlighted in red, a government official cannot simply ignore, overrule, or change what is required in an act. They are the servants, they are slaves to the act. They cannot simply decide they don't like some or other part. It is only possible in instances where the act specifically provides that a government official has some or other discretion. A good example would be the Agricultural Product Standards Act, and in that act is specifically made provision for a dispensation to be granted by what is called the executive officer to, for a period of time and to a certain extent, not comply with the law. He certainly cannot grant you a dispensation that you forever don't have to comply with the law. But even in that, even there, it's only allowed because the Agricultural Product Standards Act specifically permits a dispensation to be granted. Jumping ahead slightly, the Foodstuffs Cosmetic Disinfectants Act has no such provision. Okay. Let's then talk about regulations. So once you have an act, for example, the Foodstuffs, Cosmetics and Disinfectants Act, in the act it will say the minister may publish regulations to give effect to this law. So the regulations are the gears, the cogs, the wheels of how does this act actually get applied on the ground. And typically it's drafted inside a department, should be by the Director General, but I presume it only gets to the DG at some point down the road. The processes that are followed often correctly, I'm not sure, incorrectly, I'm not sure, is they will consult with stakeholders and then come out with a draft, which is then open to the comment by the public. So although to some extent the game is rigged because they've consulted with people before it was open to the comment by the public, it is eventually open to comment by the public. And once you've commented on it, they should consider your comment. That doesn't mean they have to agree with your comment, but they do at least have to go through the process where they consider your comments. Once the regulation is finalized, the Director General, having passed it through the legal department, will give it to the minister, who then promulgates it. So a regulation doesn't go through Parliament. It's signed off by a minister, and it's specific to his department. So obviously it's a level lower in the hierarchy of law. Acts are the highest, regulations are at the ministerial level. But again, an official cannot simply ignore, overrule, or change a regulation. If you are unhappy with what is in a regulation, the procedure is to lobby the department to amend the regulation. Now, the same process would apply to an act, but whereas amending an act can take a very, very long time. As you can imagine, the process to be followed is long, and there are sometimes years can pass. In theory, a regulation can be amended very quickly. And if we remember when R991 came out, shortly thereafter they published, for example, a correction where there were some errors. So amendments don't always have to take a very long time. A new regulation can take a very long time, as we will know from R429, which is now in, I don't know, it must be close to 6-7 years that it's been a draft. So we have the act. Under that, we have the regulations, and the regulations are under specific acts. So if it's a regulation issued under the Foodstuffs Act, it is enforced under the Foodstuffs Act. The Agricultural Department of Agriculture has no say on how you interpret or enforce a regulation issued under the Foodstuffs Act. And then we have the issue of guidelines. And obviously, I'm going to talk about this further, but guidelines is something that is more well known in Europe and in countries that have a different legal system than ours. So our acts tend not to be prescriptive to a level where every single thing is prescribed. We call that our law is not codified. When law is codified, guidelines make a lot of sense because you can refer specifically to a specific line number in an act or regulation, and you can then try and give an interpretation for that particular codified line item. But because of the nature of how our law is written, which tends to be broader in scope rather than extremely specific, the departments have started to feel that if they publish a guideline, then it helps their officials to interpret the act and the regulations. And therefore, guidelines are published after the event by departmental officials. Very often, there's no external input or commentary on guidelines. It is an entirely internal exercise with no commentary, no possibility of commentary. And it is simply a guide on how one could comply. And of course, that is only if it's correctly written. So the guideline, as the name says, is in general simply a guide. A guideline cannot go beyond the scope of an act or regulation. They can't say, oh, well, we've missed something out, so we will just put it in the guideline. Unfortunately, it doesn't work that way. If they've left something out and they would like to have it as part of the law, then they must go through their processes and either amend the regulations or the act or both, and not simply try to foist it into a guideline. And of course, guidelines as such are unenforceable unless the act or regulation calls for guidelines. So there are some laws. I remember a couple of years ago doing an opinion for a company, not on this particular guideline, but on another guideline. And in preparing that legal opinion, we found that there were in fact some laws which specifically provided that the Director General shall issue guidelines on X, Y, Z. But even then, it's got to be very specific. He can't just say generically, and there will be guidelines published. And in any event, those guidelines cannot go beyond the scope of what is in the act or regulations. It's not a simplified process of extending the law. And I'll talk a bit further about the guidelines later. Then we get onto the self-regulation, which is Advertising Regulatory Board, ARB. Those of you who don't know, the Advertising Standards Authority went bankrupt and was eventually replaced by the Advertising Regulatory Board, which does the same thing, and in fact has simply adopted their appendices to the code and so on in many respects. So the ARB is a voluntary body, and specifically they have an Appendix E to their code, which deals with breast milk substitutes and also bottles, teats, and the like. And it's quite interesting because they have some things in that appendix which I do not find in R991. But bearing in mind that they are not a regulatory body as such, they are, let's call them a checkpoint if advertising or labeling is of such a nature that a consumer would complain or a competitor would complain. And then we have another body called the MCA, Marketing Code Authority. Now, I'm very surprised, but most people don't know who the MCA are. I see that some of the people that are part of this are from pharmaceutical companies, and they will know what MCA is. So the MCA may in fact turn out to be more relevant to these products, but at the moment the MCA has been quite quiet, and as you'll see when I talk about them a bit later, they tend to focus more on complementary medicines and medicines. And of course, the one thing about self-regulation is that it's unenforceable unless the person is a member or if it's referenced in a law or a regulation. So what has happened, for example, with the ARB and its predecessor, the ASA, just to give you an example, there were consumer complaints about health products. And the ASA considered the consumer complaints about health products. And the companies that sold the health products took on the ASA and went to court and won. They didn't win on the basis that their ads weren't misleading or that their ads were compliant, etc. They won on the basis that as they are not members of the ASA has no right to investigate them or make any rulings or try to enforce any rulings against them. So it's very important. These self-regulatory bodies are in a way clubs, and a club only has authority over its members. It does go a little bit further in that the club can order its members not to advertise a product which they feel contravenes their code. But they don't have the power to order the person who made the ad or published the ad to do anything unless that person is in fact a member. So the ARB is there. I was very surprised. I went on their website. They've in fact dealt with a very large number of complaints in the last year and a half or whatever that they've been around. I haven't seen one, just quickly going through it, that seems to relate to this particular industry. But when the ASA was in existence, it did in fact have some issues with breastfeeding and so on. Okay, so finally moving on to professional bodies constitutions, we have ADSA, Nutrition Society, IFA, SAFOST, etc. And all of these bodies are voluntary associations of professional members, and the members are bound by a constitution to which they subscribe. there might be what was the word I'm looking for? A code of conduct or a code of practice which you have to comply with, otherwise you can be expelled. There can be various such measures in place. But you can imagine it's internal as between the membership. And clearly all of these professional bodies' constitutions are set up in the interest of members' professional status and development. They are not there for the public to go and lodge complaints to. They're not really set up for that. Although, as I say, some do have a code of conduct, and they have, in fact, processes whereby they can discipline somebody. And then let's get to the final point, which I'm going to be addressing today, which is constitutional right to free speech. And of course, we all know the Constitution is the benchmark against which all laws are measured. Actually, not just laws, anything we do is measured. You can, however, have non-discriminatory private arrangements, which are largely excluded then from the type of arrangement. You know, what you wouldn't be able to do in a law, because it's the state as against the citizen, you can often in a club setting or in a private body setting have such rules in place, as long as they are not discriminatory. But from a legislation point of view and regulation point of view, one has to look at the fact that rights are always balanced and the greater good prevails, to put it simplistically, and I will address it in far more detail further. But for example, before the lockdown, tobacco advertising was an example where free speech was lost. Quite frankly, under the lockdown, we all know free speech is lost, because if you go out and make some sort of statement, which you may even think is tongue-in-cheek about COVID or treatment of COVID or how to avoid COVID, you could in fact be prosecuted for your free speech. Now, whether that would stand in the Constitutional Court, only time will tell. What we do know is that tobacco advertising has been to the Constitutional Court, and we know that free speech can be limited in the interest of the greater good, public health. Okay, so those were the main, let's call them hierarchical issues in terms of the pyramid of how the regulatory framework stands. I suppose the Constitution should be right at the top, but it's easier to put it at the bottom because it's in fact the foundation of everything. So let's now move on to the first of the laws, which is the Foodstuff, Cosmetics and Disinfectants Act, 54 of 1972. Yes, it's almost 50 years old, but it has been amended quite a lot of times. So in the Act itself, we have a definition of an advertisement, we have definition of what is a foodstuff, and very importantly, the law provides for powers to draft regulations such as R991 and what is criminal liability and how you can be prosecuted and what the potential fines and imprisonment, etc. is. So that is all at a very high level. The law, the Foodstuffs Act itself does not deal specifically with infant food or food for special medical purposes, or it's an umbrella which empowers the drafting of regulations which will then deal with specific issues. And then some of the specific issues which I thought are important to deal with are the fact that there are labeling regulations, R146. There's the Foods for Infants and Young Children, R991. And then, of course, the whole issue of whether or not they in fact have powers to draft guidelines, which the Department of Health seems to like to do. There are guidelines under R146, there are guidelines under R991, and there are probably guidelines under other regulations which I haven't even mentioned. What is interesting is that sometimes things get published and go nowhere. So we have the following pending regulations, which were published with an invitation to comment and then went nowhere. We have the labeling regulations R429, which included food for special medical purposes, but then a lot of comments were submitted and nothing happened. And then also there was R591, which was supposed to be an amendment to R991. And again, after a lot of comments were submitted, it was never finally published. So Section 2, Regulation 2 under R146 is where the requirements for labeling, etc. start. So what we need to understand is that these regulations are all in a way in parallel to each other because they all fall under the Foodstuffs, Cosmetics and Disinfectants Act. But in general, one regulation defers to another regulation, that one will take precedence. So therefore I say, unless permitted by another law or regulation, the following will apply, is that no person shall manufacture, import, sell, or offer any packaged foodstuff for sale unless the foodstuff container or the stock from which it's taken is labeled in accordance with these regulations. Then it refers to the advertising of a foodstuff, and it says you can't include any information, claim, reference, or declaration which is not permitted in accordance with these regulations, but bearing in mind that if there's another specific regulation such as R991, then to the extent that that regulation deals with something, that regulation takes precedence. To the extent that that regulation is silent, you still have to apply this one. Then it says, in Regulation 6 under R146, no label of advertisement of any nature of a foodstuff shall refer to the Act, food-related food regulations, the Department of Health, provincial or local government, or official of the said department, provincial or local government. There are similar provisions in R991, which we're going to get to, which are even more far-reaching. Then Regulation 13 is the prohibited statements regulation in R146. And it's prohibited statements on labels and in advertising. So it's not only on labels. And some of the prohibitions which are really important in our context today are that there's a prohibition to claim that your product is endorsed by a health practitioner unless it has been approved by the Director General of Health, and the endorsement is by a generic health promotion entity. So it's not a company. I've been involved in debates regarding this. If a certification body that charges a membership fee wants to be able to endorse products, can they do that? Are they still involved in generic health promotion if they charge for use of their logo? Those are really important questions. Then endorsement by an individual implying a nutrition claim. So you have somebody, a famous sports person, or I suppose in the case of infants, somebody who says holding a baby and makes some sort of statement about how well their baby is doing or something like that. So you can't do that. There's no endorsement permitted by an individual implying a nutrition claim. Then there's a complete and utter prohibition on use of the words health or healthy or other words or symbols implying that a foodstuff has health-giving properties. The issue of using words such as wholesome or nutritious or any other words with a similar meaning in any manner, including the name and trade name. So it's very important. You can't even have it in your product name or trade name. Then it's also prohibited to have a claim that a foodstuff provides complete or balanced nutrition in any manner, including the name and the trade name. Now, obviously, that won't be a problem if you, for example, registered under the Medicines and Related Substances Act, because then your special food is in fact a registered medicine or it's a complementary medicine, and then in fact it doesn't fall under this regulation. But a normal foodstuff can't claim that it provides complete or balanced nutrition in any manner. And then of course you're not allowed to make any medicinal claims on a foodstuff, quite frankly, because then it's a medicine under the Medicines Act, and I'll get to that. So what happened to R429? Because obviously R429 is the one where FSMPs surfaced. So R429 was published for comment on 29 May 2014, which tomorrow will be 6 years, by the way. We should wish it a happy birthday. And in there, Regulation 66 deals with the labeling of enteral foods for dietary management of persons with specific medical conditions, FSMPs. But it specifically excluded infant food. Also, in Guideline 17, it dealt with FSMPs, but Guideline 17 was a mishmash. It looked like it was somebody's thesis or some sort of document which was simply appended at the end and referred to as a guideline. What happened was, and members that are on the call today will remember, there were detailed comments submitted regarding the FSMP provisions in R429. But because R429 went nowhere, this has simply gone into abeyance. There is talk that there will be a separate FSMP regulation I'm pretty sure that with the current crisis in South Africa, that's probably fairly low down on the agenda at the moment. But certainly, R429 can be considered as lapsed. And if they want to revive R429 in any form, I'm pretty certain they would need to republish it again for comment, because so much time has passed. I don't think it would make logical sense for them to take the comments received 6 years ago and suddenly say, well, here's a regulation, we considered the comments, we made the changes. I think legally they would have to republish it for comment. So R429, just to sum up, is of no force and effect. Don't quote it, don't cite it, don't rely on it, don't look at it and say, oh, but R429 said this or said that. It's just there historically. And then, of course, under the FCD Act, we have the elephant in the room, R991, which is the regulations on food for young infants, for infants and young children. Now, you're all quite familiar with this, but in any event, I want to go through some of the more important definitions, because I think it will really help with the understanding of what the thinking was when drafting this regulation. So, for example, they had a definition of blends, which means a blend or mixture of cow's milk, components of cow's milk, vegetable fats, and or glucose. It's obviously important because there's some overlap or possible not overlap with the dairy regulations when you've got cow's milk and is it a dairy blend? We can talk about that later. Then brand names means a trademark or name given by a manufacturer or distributor to a designated product. There's some really key words in these regulations. One of the really key words is designated product or range of designated products, and includes brand logos. Now, why this is so important is that in terms of R146, they refer to a name or a trade name. And there is debate that neither name nor trade name necessarily include the trademark, the actual brand name. So they have made it very clear in R991 that they want to specifically regulate the use of branding, including brand logos. I would have written it differently. I would have specifically referred to the word trademark. I don't know why they avoided it, but be that as it may, the brand name is defined and used in the regulations. Then we have the next important category, which is what is a complementary food. And it means any foodstuff, whether in liquid, solid, or semi-solid form, given to an infant from age of 6 months as part of a transitional process during which an infant learns to eat food appropriate for his or her development stage while continuing to breastfeed. And then I just thought I'll highlight, it says, or be fed with an appropriate formula. Because the concept of formula is not entirely thrown out the window by these regulations. So there's complementary food. Then we have definition of designated product, and designated product includes a whole number of categories. Infant formula, follow-up formula, infant or follow-up formula for special dietary management for infants with special medical conditions, which is FSMPs, I suppose, for infants. Complementary foods, which we've just defined. So designated product is a bigger category, and inside designated product, you've got the infant formula, follow-up formula, complementary foods. Then you've got liquid milks, powdered milks, modified powdered milks, or powdered drinks marketed or otherwise represented as suitable for infants or young children. So it's quite important because something like a liquid milk or a powdered milk, which is not modified, simply because you are saying it's for children, can bring it in as a designated product. Then we've got under designated product, feeding bottles, teats, and feeding cups with spouts, straws, or teats. So they've included that. And then there's the very broad catch-all. Any other products marketed or represented as suitable for feeding infants and young children, but only to the extent that the minister publishes it in the Gazette, which hasn't happened. So at the moment, designated product is very, very broad. And in these regulations, this obviously comes up quite often, especially when it comes to restrictions on marketing, etc. Directorate in this instance is the nutrition department responsible for nutrition in Department of Health, whereas R146 falls under a different directorate. So it's interesting, although they're all under the Foodstuffs, Cosmetics and Disinfectants Act, R146 falls under a different directorate than R991. Distributor is a person or corporation or other entity in the public or private sector engaged in the business of marketing or distributing any designated product. So there we go, designated product, wholesale or retail level. So if a designated product is involved and you in any way trade or etc., then you're a distributor. Then we've got follow-up formula. Now, follow-up formula means a product formulated industrially according to the composition of which is based on the applicable codex standard and marketed or otherwise represented for an infant from 6 months on or a young child. Now, let's just compare that to complementary food. Foodstuff, whether liquid, solid, or semi-solid form, given to an infant from age of 6 months, so there's an overlap, as part of a transitional process during which an infant learns to eat food appropriate for his or her development stage. So follow-up formula would be a type of complementary food, but it then has to be in terms of the applicable codex standard. Infant means a person not more than 12 months of age. Now, when we speak about R591 and what happened to it, for example, one of the amendments they tried to make in R591, which never happened, was they wanted to change this to means a child not more than 12 months of age. But is a child not a person? Anyway. Then we have a definition for young child. And in this context, it means a child older than 12 months, but younger than 3 years. So there are various categories, infant, young child, and depending on where you fall, some of the products are for one or other category. Sorry, jumping around. Then we have infant formula. So we've had complementary food, follow-up formula. What is an infant formula? It means a formulated product. Again, it's got to be formulated. It's not something that's just there. Specially manufactured in accordance with the applicable codex standard to satisfy by itself the nutritional requirements of infants during the first months of life up to the introduction of appropriate complementary feeding. So you remember in R146, there was a prohibition on claiming that a foodstuff provides all the nutritional requirements. Well, here's an exception because R991 says, in fact, that's what an infant formula does. And then infant or follow-up formula for special dietary management for infants with special medical conditions means a formulated product that complies with the latest adopted version of this codex number with that title. So FSMPs are included in our law, but only insofar as they are for infant and follow-up formulas. Who is a manufacturer? So they obviously try to avoid situations where people have contract manufacturers and contract packers and all sorts of arrangements. So they went very broadly. It's a person, corporation, or other entity engaged in the business of manufacturing, such as production, preparation, processing, preservation, or any other manufacturing process of a designated product, so that whole category, whether directly, through an agent, or through a person controlled by, or under an agreement with such person, corporate or other entities. So as I said, they've tried to include in here contract packing, contract manufacturing, resellers, importers, everybody in the supply chain can be considered a manufacturer, depending on what they actually do with the product. Yeah, as I say, through an agent. So if you're an importer and you instruct the manufacturer overseas to make it for you in a specific way, then you would be seen as the manufacturer. Marketing means promoting, distributing, selling, or advertising a designated product, and includes product, public relations, and information services. Obviously, this gets dealt a lot further from Regulation 7 onwards, but this is just an important definition, including the use of professional service representatives or any person acting on behalf of a manufacturer or distributor. So again, they've thrown the net very, very widely because marketing includes any of those things. And when we get to the marketing and promotion section, you'll see why it's important that this is such a broad definition. A medicinal claim means a claim which states or implies that a product has the property of treating, preventing, or curing human disease. In order to be permitted to make a medicinal claim, a product must be classed as a medicine. Now, this is very important because in the Medicines and Related Substances Act, there are definitions of what is a medicine. And if you are defined as a medicine, you could then end up being a complementary medicine. So complementary medicines are registrable, and a complementary medicine can be a composition which is being used as a health supplement under certain conditions. So it may be that a follow-up formula or one of these products in fact becomes a complementary medicine depending on what is said on it or about it. So in the Complementary Medicine Regulation, this one here, 859 of 25 August 2017, it says, complementary medicine means any substance or mixture of substances that originates from plant, fungi, algae, seaweeds, lichens, minerals, animals, or other substance. I'm not sure if anybody that's listening can think of another substance. If you're not a plant, a fungi, an algae, a seaweed, a lichen, a mineral, or an animal, I'm not sure what else there is. But anyway, is used or purporting to be suitable for use or manufactured or sold for use. And then here's the kicker. In maintaining, complementing, or assisting the physical or mental state, or to diagnose, treat, mitigate, modify, alleviate, or prevent disease or illness, or the symptoms or signs thereof, or abnormal physical or mental state of a human being or animal, and is used as a health supplement or in accordance with one of the disciplines determined by the authority. So it is possible that you could have a product which you consider to be an infant food or a food for young children, which in fact may also be considered a complementary medicine and requires to be registered. So what are the various designated products which are included? And I thought I'll just mention the ones for the bottle manufacturers and so on. So designated products include a feeding cup, which means a cup with an artificial teat, spout, or straw, which is used to feed infants or young children. And a feeding bottle means a device with an artificial teat, which is used to feed infants or young children. Now, it's quite interesting because a feeding cup, you'll also find at old age homes. You find that they give elderly these cups to make sure they don't spill tea on themselves. People have dementia and Alzheimer's and Parkinson's and so on. So a feeding cup on its own only becomes a designated product when it is used to feed infants or young children. But the same cup packed differently would not be a designated product, just to give you an explanation there. Okay. And then there's a definition of gift, which means something given free of charge, and in this context includes, but is not limited to, free samples of designated products, meals and refreshments, diaries, stationery, calendars, cot tags. Is a cot tag something, if you forget your baby's name, then you've got a tag on it and you know what your baby's name is. Stickers, growth charts, prescription pads, tongue depressors, or any other item of whatever value by manufacturers, distributors, retailers, and the representatives of the designated product. So when they prohibit gift giving, it pretty much closes the door on everything. But we'll deal with that when we get to that section. Okay. Then nutrition claim. Nutrition claim means any representation that refers to a specific nutrient or food constituent content of a particular food. But very importantly, the following do not constitute nutritional claims. The mention of substances in the list of ingredients, the mention of nutrients as a mandatory part of nutrition labeling, quantitative or qualitative declaration of certain nutrients or ingredients on the label, but only if required by national legislation. So you can't decide to highlight a particular nutrient unless it's required by law that you do so. Very important. Quantitative or qualitative declaration of certain nutrients or ingredients on the label if required by national legislation. Then let's talk about promotion. What is the definition of promotion? It means to employ any method or scheme or design of encouraging or enticing a person or group of persons in whatever form, to purchase or use a designated product, and includes but is not limited to, again, this wording, include but is not limited to. So if you come up with some clever thing, just because it's not listed here doesn't mean it doesn't constitute promotion. Advertising, point of sale advertising, giving of samples, special sales, free supplies, donations, sponsorships, gifts, whether related or unrelated to purchases of designated products, free utensils or other articles, prizes, carrier bags with pack shots or product logos. So they obviously went and looked at what were all the things that were happening, or that maybe they were told by other bodies internationally was happening in their jurisdictions, and they tried to make a list. Now, marketing people are very clever, and you can never have a complete list because there'll always be somebody who comes up with something that's not on this list. There's no doubt. But just remember that there is this statement here, that it's not limited to these. So if it's in a similar vein, it's probably going to be considered promotion. Then we have sponsorship, which means any financial or in-kind assistance to a person, group, or activity alone or with other, and sponsor has a corresponding meaning. Some of the questions that were sent through, which I'll deal towards the end, dealt with sponsorship. So it's quite important to understand what is the meaning of sponsorship in these regulations. Financial or in-kind assistance to a person. Okay, so I rattled through a whole lot of definitions, but I thought it's just important that we refresh ourselves as to what those things mean before we climb into the regulations. So just like R146 had certain prohibitions, R991 has its own prohibitions, in addition to whatever is in R146. So there's a prohibition on stating on any other foodstuff that it's suitable for infants younger than 6 months of age. So if it's not in R991, you may not represent that it's suitable for infants younger than 6 months of age. There's a prohibition on having a product which is labeled and packed appropriately according to stipulations of these regulations. Unless it is labeled and packed appropriately according to the stipulations and regulations, other applicable regulations published under the Act, and relevant codex standards. Provided that where conflict exists between the codex standards and these regulations take precedence. So it's not going to suffice to say, oh, but codex allows me to do something. If there's a conflict between codex and our regulation takes precedence. If our regulation is silent and there is a codex standard, you must apply the codex standard. Any foodstuff must, in terms of these regulations, must be sold in a hermetically sealed container, which cannot be, so you're not allowed to sell a product unless it's sold in a hermetically sealed container, and which cannot be resealed or closed tightly during usage and subsequent appropriate storage. Regulation 2.2 says you're not allowed to show graphic representations other than preparation, but you can include the image of ingredients, composition of prepared product, of a complementary food for infants or young children. So on those products, complementary foods, you're allowed to do these things. You're not allowed to make any negative statements about human milk. You're not allowed to directly or indirectly indicate that a product is for all infants. You can't say it's suitable for all infants. And you have to contain the nutritional information on the label, both per R991 and R146. So the nutritional information has to comply with both of these regulations for a foodstuff. The company logo, brand name, and logos indicating endorsement by specific religious certifying organizations shall be permitted, provided they do not contain a picture of an infant, young child, or other humanized figure. One can have a lot of debate as to what is a humanized figure. But sure, if it's in your logo or in your brand name, you're going to have a problem. At the very least, you're going to have a lot of explaining to do as to why it's not a humanized figure. We, of course, have similar issues regarding, for example, the fruit juice regulations. We have a fruit-flavored artificial drink let's say by brand, something like a Fanta. And can you have a picture of an orange on it? Or can you simply have some sort of artistic impression which you can't really identify as a fruit, but somebody who knows it's orange flavored would probably know it's a fruit. Regulation 2.4 says you're not allowed to have any health, medicinal, or nutritional claims on your product. But in any event, if you had a medicinal claim, you wouldn't fall under R991 anymore. You would then have to register with SAHPRA, because you would in fact then be complementary medicine, or even a medicine under the Medicines Act as such. So very important. You have to register with SAHPRA if you have any controlled substances as an ingredient. But in any event, as I say, then your product will be a medicinal product. And Annexure B lays out the format for all nutritional information which is required on a foodstuff. Jumping to Regulation 212, the label of a designated product shall not refer to, promote, or advertise any other designated product. So you cannot try to promote another product on the label of one product if the other one is a designated product. You can potentially market or promote a non-designated product on the label of a designated product. Regulation 213, no toys or any other forms of gifts or tokens may be referred to, inserted, or sold with the designated products referred to in sub-regulation 2.1, excluding measuring spoons and scoops. So obviously that you're allowed to put in. No incentives, enticements, or invitations of any nature which might encourage consumers to make contact with the manufacturer or distributor of a designated product, which might result in the sale or the promotion of a designated product for infants or young children, shall be used on the label or in the marketing of a designated product for infants and young children. Now, Regulation 214 reminds me very much of the British tobacco litigation regarding their right to contact smokers and to try and market their products to them. I haven't seen any complaints regarding this, but I presume in social media, if you were aware that somebody has a baby and now you contact them on social media to interest them in your product, I'd like to see how the department deals with that. Because it says no incentives, enticements, or invitations of any nature which shall be used on the label of the product. Okay, that's fine, but in the marketing of a designated product. So social media may be seen as marketing of the designated product. I'm not sure if anyone's actually doing this in this sphere, but certainly that's what happened with the tobacco products and what that court case was all about when we talk about the constitutionality of regulations that prevent you from contacting people and telling them about your product, as opposed to generically marketing them. No statement or claim shall be made on the label in any other manner which conveys a message that a specific company name or logo or brand name represents itself as experts with regards to infant and young child feeding or nutrition. I think it's quite clear. I'm pretty sure it creates all sorts of problems in companies that do more than just these products, specialize in a particular area of the market which includes these but goes beyond these. And then, subject to the provisions of these regulations, the labeling of foodstuffs for infants and young children must also comply with R146. So in case you weren't clear, not only must you comply with R991, but this clearly says that you also have to comply with R146 for matters not dealt with in R991. Okay, Regulation 3 deals with specific labeling requirements. Really, I'm not going to go through that because for every product it's different and it's just a whole lot of detail. Regulation 4 deals with specific requirements as well, but take note of the following: that complementary foods and liquid milks, powdered milks, modified powdered milks, or powdered drinks marketed or otherwise represented as suitable for infants and young children shall not, and there's a couple of prohibitions, use names, phrases, or expressions such as maternalized, humanized, breast milk substitute, or any derivative form of these terms, etc. B is more interesting because this has come up from time to time. Use expressions or names that may be understood to identify the product as suitable to feed infants, such as the expression first growth, first food, from the start, best start in life, or similar terms or expressions. Now, this has in fact come up. I'm not going to go into it now, but there are products on the market which walk a fine line when it comes to these prohibitions. Yeah, so suitable for infants or young children. But here it talks about that the product being suitable to feed infants. So if you had a product for young children, would it be in contravention of B? Because this talks about identifying the product as being suitable to feed infants, not young children. Regulation 5 deals with specific labeling and other requirements of sweetened condensed milk, imitation dairy, and goat's milk products. I'm not going to go into that. Regulation 6 deals with specific labeling and other requirements of feeding bottles, feeding cups, and teats. And there's a question on this in the question session where I'll deal with this in detail, but I'll just quickly mention it here. So 6.1 says they must be packaged. You cannot just have a drum and all the bottles or cups or teats are just thrown into it and you pick one out. What does packaging mean? Does packaging mean it's got to be in a box? Does packaging mean you can have like a cardboard, I don't know what you would call it, around the neck of the bottle, which has information on it, but it must be packaged. It must contain cleaning instructions and warnings. Must not show any graphic representation other than for illustrating cleaning and sterilization and the logo of the manufacturer or distributor. And there's a question on the specific point later on. Must not contain any words or images that create the impression that such feeding bottle and teat are manufactured in accordance with the recommendation of a medical or dental practitioner or other registered persons. So you'll remember R146 that dealt with food, prohibited endorsements by medical practitioners, etc. But obviously, a bottle, feeding cup, a teat is not a foodstuff. It doesn't fall under R146. Yeah, they specifically prohibit endorsements that it's recommended by a medical or dental practitioner or any other registered person. You're not allowed to make any comparisons to breastfeeding, and then right at the end, you're not allowed to use BPA in the plastic from which these products are made. There's a section in the Appendix E of the Advertising Regulatory Board, and I might pop it up later on the screen, because they have further requirements on how these products should in fact be advertised and marketed, and I'll show it to you. Okay, this obviously is the elephant in the room, Regulation 7, sale and promotion. Now, I don't know if you want to take a 5-minute break if everybody wants to get up from their computer, or do we just soldier on? It's 1 hour now. Nasneen, I think you're muted. There you go.
We can do a 5-minute coffee break if everybody wants to maybe just get a quick cuppa and come back very quickly. How are you placed, Janusz? Are you still good to go?
I'm good to go, but I know people sometimes, if I'm standing on stage and speaking, they start getting all antsy about this stage. So before I start a whole new important topic, I thought maybe if people want a break, they can take it now.
Let's take a quick 5-minute break and we will start exactly at 11:08.
Okay, perfect.
Are we all good to go?
I'm here.
All right.
Good. Nazneen, shall I proceed?
Yeah, we can go. We can go. Thank you.
Okay, great. Okay, all right. Let's get on to a really, really important section of all of this. Obviously, once it's been made and packaged and all of this, that's one thing. Where I've had quite a number of interactions for my clients has been problems relating to sale and promotion, often unintentional. At retail level, mistakes have been made in how products are presented. Store managers that realize they've got stock that's short dated and want to get rid of it and decide to promote it and so on, not understanding that in fact there are very strict rules against promotion of these products, regardless whether they're going to expire or not. So, first of all, let's start at 7.1. No person shall undertake or participate in any promotional practice or device advertising in respect of infant formula, follow-up formula, infant or follow-up formula for special dietary or medical purposes, liquid milks, powdered milks, modified powdered milks, or powdered drinks marketed or otherwise represented as suitable for infants or young children. I highlighted the feeding bottles, teats, and feeding cups as pouch straws or teats because, interestingly, it's there as well. I suppose if the thought pattern is that infant formula and follow-up formula will be fed through these products, and then again any other product that the minister may publish. So it's not the full list of designated products. It's a shortened list compared to the full list of designated products. If one goes back up to designated products. So the designated product list also includes complementary foods, which do not appear in 7.1. Okay. Hope that didn't make you dizzy, me scrolling up and down through the slides. 7.2. Promotional practices or devices in respect of product listed in sub-regulation 7.1 include but are not limited to. So the things that are prohibited, what you're not allowed to do are sale devices such as rebates, benefits in kind, kickbacks, or any other pecuniary advantages. I gotta love the sudden use of vocabulary there. Special displays to promote sales. Advertisements about the availability of the product at a specific retail outlet and the price of the product, tie-in sales, discounts in any forms, competitions of prizes, or any other incentives and gifts. And as I say, I have seen unintentional problems where a product was marked down to get rid of it, was moved to the front of the store onto the gondola ends, as they called it, because they need to move the product because they're scared it's going to expire and then it's a big loss. But in fact, it's not allowed. You're not supposed to be setting up a special display to promote sales. Then direct or indirect contact. Oh, let me go back one step to A. So it's really important that some of these come down to intention, because special display to promote sale can be seen as having it in a special position, but is it special because it's intended to be special? Or is it special simply because that's how the store is laid out and that happens to be the section where the baby clothes and the baby food is sold and it happens to be near the door? So some of these issues are not as clear-cut as simply reading the wording. B, direct or indirect contact between company personnel and members of the public. So you'll remember I started talking about social media. And although the people who wrote these regulations, I don't think thought of social media, there is this here, because direct or indirect contact between company personnel and members of the public in furtherance of or for the purpose of promoting the business of the company with regard to the products referred to in sub-regulation 7.1, and for purposes of these regulations, indirect contact specifically includes internet sites hosted on behalf of South African entity on an entity that does business in South Africa, television and radio, telephone or internet helplines, and mother and baby clubs, but excludes contact in regard to product quality complaints and adverse events. So When B was written, clearly social media was not a big thing, because you can have social media contact which does not necessarily fall specifically into one of these categories. But don't forget that it will still fall within the generic description here of direct or indirect contacts. C, the distribution of any information or educational material on the nutrition or feeding of infants and young children, except in accordance with Sub-Regulation 7.4. Now, on recent trip to America, I heard some very, very interesting radio advertisements, and they don't necessarily relate specifically to these products. In fact, they were to do with cannabis and CBD, but the FDA regulates cannabis and CBD, and you're not allowed to advertise the medicinal benefits of either of them. So this is the way the advertisement went. It said, we sell this product, Google the following term, and then come back to our website and order the product. Now that term wasn't in itself information about this specific product. It was referring to a generic website where there was generic information about the product. So there are ways that people try to get around these things, but the distribution of any information or educational material, as I say, marketing people are very clever, and they do find ways of working their way around some of these things. Promotional items such as stationery, t-shirts, or other items of clothing that refer to products contained in Sub-Regulation 7.1 of these regulations. I cannot see a stationery company or a t-shirt company or headgear company making promotional items, sorry, that also makes designated products, the ones in 7.1. But I suppose it is possible that a company making household utensils also makes bottles, teats, and feeding cups. And then the question could rightly come up is that a promotional item, or is it simply just another product that they sell in the normal course of business, but is not a designated product in itself? Then the brand name of a product referred to in Sub-Regulation 1 when used at any event for the general public. Again, this refers to an event. Social media probably not considered. Advertisements in written publications, television, radio, film, electronic media, email, video, telephone displays, exhibitions, outdoor advertisements, etc., etc. Electronic media may or may not include social media. I would have to think about that carefully. Donation to or distribution of any equipment, including the building, renovation, or maintenance of a health establishment. But very important here, it's only where that bears the company name or logo, and which is specifically intended for providing care to infants and young children, pregnant women or mothers of infants and young children, and it's prohibited without the prior approval of the Director General or a person designated by them. There are one or two of the questions actually come down to this point, and it's just important to note that it becomes prohibited when it bears the company name or logo. H, research grants or any other financial assistance, again another important one, research grants or any other financial assistance relating to infant or young children nutrition provided to healthcare personnel working in a health establishment or healthcare personnel linked to a health establishment, unless prior approval has been obtained from Director General. But now we need to understand that it's financial assistance relating to infant or young children nutrition. Well, I suppose the research grant would be relating to, the research would be relating to infant or young children nutrition. Then I, financial contributions or sponsorship to healthcare personnel working in infant and young child nutrition. Talk about that a bit later in the questions as well. Sponsorship of meetings. Can stop here for a second. Sponsorship of meetings targeting healthcare personnel where infant and young children nutrition is the sole, okay, sole is easy, or partial topic of discussion. So if it's mentioned at all at the meeting, it's a partial topic of discussion. But what happens if it was never intended to be? So you have a meeting, and during the meeting, somebody from the floor starts discussing an issue which relates to infant and young child nutrition, whereas that was never the intention of the stated intention of the meeting. And then it says, you're not allowed to make these sponsorships of meetings unless contribution or sponsorship is made into a pool of funds for Congress organizers. So it's not saying that a company must put all the money in a pool and sponsor people. What it's saying, the company must donate to the Congress organizers so that they have a pool of funds from which a fair and transparent process will be followed to elect and sponsor delegates to attend such events. And sponsored delegates should have no obligation to the company involved. There's another issue here, and that is, when is someone a delegate and when is someone a speaker? I have often been invited to speak at conferences where I'm not a delegate. I don't stay. In fact, Nutrition Congress a couple of years ago and so on. I arrive just before my session, I present at my session, and I leave. I don't attend the dinner. I'm not a delegate. So does this relate to someone that's going to come and speak at a Congress, or is this only for attendees that will attend all or most of the sessions? But it's very important that the pool of funds is given to the Congress organizers. The Congress organizers will in turn determine which candidates will be eventually sponsored to attend as delegates. Then 7.3, no person shall sell, promote, or advertise any designated product. Now it includes complementary foods. So although 7.1 didn't include complementary foods, now complementary foods are included through healthcare personnel or health establishment. Prohibited promotional practices include but are not limited to provision or offer, direct or indirect, of any gift in cash or kind, etc. We've been down this before. And it says, notwithstanding this, an institutional pharmacy in a private health establishment may sell a designated product, but may not advertise or engage in promotion of the designated product. So it's just there, it's available. You walk in, you pick it up, you buy it. But interestingly, now it's also complementary foods. Maybe not. B doesn't deal with complementary foods. B deals, oh no, but designated products do include complementary foods. Apology for that. I'm debating it with myself. So I'm not sure why they felt it necessary to say any designated product, including complementary food, because complementary food is a designated product. No manufacturer, distributor, retailer, importer, or person on behalf of the aforementioned shall produce or distribute any educational material on infant and young child feeding that promotes any products which are listed in 7.1. Again, complementary foods are not in fact included here. So no manufacturer, distributor, etc., would be able to promote, etc., any product referred in sub-regulation 7.1, but they could do it for a complementary food. No manufacturer, distributor, retailer, importer, or person on behalf of the aforementioned shall produce, distribute, or present education information relating to infant and young child nutrition as a whole. Now one can imagine there's some sort of interaction between 7.4 and 7.5. 8 states, no health establishment shall promote and or distribute gift packs that contain or refer to any designated products, individually or in combination with other goods. Okay, that's quite clear. Oh, jumping around. Okay, then we get to regulation 9. No manufacturer or distributor shall distribute free or at low cost supplies or samples of designated products. This is important, designated products, to healthcare personnel or any other person, or to a health establishment subject to sub-regulation 9.2 and 9.3, and there is no 3, but anyway, Notwithstanding the provisions of that, a person, manufacturer, or distributor may distribute free or at low cost sales of designated products to hospices, orphanages, or places of safety, provided that they do the following. In other words, you can't distribute substandard products. The products have to comply with codex standards and the regulations. And also, if you start giving it, you have to continue giving it for as long as the infants concerned need them. You can't set somebody off on the road of using your product and then say, well, now you have to start buying it. And then, of course, you may not resell the designated product. C obviously applies to the recipient, the hospice, the orphanage, the place of safety, so that they don't then resell the product you give them. I think the implication of that is that if you do give them product, they probably need to be marked or stamped in some way which is not for resale or something to that effect. No person within any health establishment shall display or cause permit to be displayed in a unit taking care of infants or young children, pregnant mothers or mothers of infants and young children, any designated product, so you can't display them. You can't display the educational materials bearing the brand name or any description of the designated product, or the name and or logo or both of the manufacturing or distributing company of designated products when the material includes any message about infant and young children nutrition or feeding practices. So you could display the name and or logo of a manufacturing or distributing company of designated products as long as that material doesn't have any message about infant and young child nutrition or feeding practices. That's how I read 10C. 11. A person, manufacturer, or distributor may provide technical scientific material to a healthcare provider, provided that, and there's an issue around what is technical scientific material, we'll discuss a bit later. Such information or material is restricted to current scientific and factual matters and is in accordance with the relevant regulations under the Act. As you can imagine, just thinking of the COVID-19 situation, what are current scientific and factual matters can in fact be a matter of opinion. One person's fact is another man's opinion. The material bears no health, medicinal, or nutritional claims, whether in text or picture format. It relates only to the technical aspects and methods for use of the designated product. So in fact, the technical aspects and methods are not about what the product does, how it prevents some disease or something like that. It relates only to the technical aspects and methods for use of the designated product, and it excludes any promotion of the designated product in any manner. So it's very, very limited to what information you can give to a healthcare provider. Okay, so that was R991. Then they came up with R591. And just to highlight something to you, Regulation 9 of R991, clearly there's an error in it. I mean, it refers to Regulation 9.2 and 9.3, but there's no 3, etc. So R591, in fact, included a correction of Regulation 9. It went on until 9.4. There was a 9.1, a 9.2, and a 9.3, and a 9.4. But the draft was published on 7 July 2015. There were many industry comments. The amendment would have dealt with several issues which remain outstanding, such as free and low-cost supplies of complementary foodstuffs. But the amendment was never promulgated and accordingly has lapsed. So R991 has had one correction to it. It didn't have the major amendment to it. So moving on now to the Department of Health guidelines. This is taken off the front page of the guidelines, and I think this in fact answers the most important question, is what is the legal effect of these guidelines? And let's read what they themselves say about their guidelines. So this is the front page of the guidelines. It says, these guidelines represent the National Department of Health's view, it's an opinion, it's what they think, on how the regulations should be interpreted. They don't say, this is how the regulations must be interpreted. It says, this is how they think they must be interpreted. This document has been produced to provide advice on the legal requirements of the regulations and should be read in conjunction with the legislation itself. Sure, because you have to comply with the legislation, not with the guideline. The text should not be taken as an authoritative statement or interpretation of the law. Only the courts have this power. So just to be absolutely clear, these are just simply the thoughts of people at Department of Health on what the regulations mean. Now, I have this right across the board with various regulatory departments, agriculture, trade and industry, health, where in a meeting they'll say to me, oh, but that's what we meant to say. What they meant to say is no value in law unless it can be read in from what is written. If I write something, I can't later say in law that actually I meant to say something else. If there's more than one way to interpret something which is written, there are two clear interpretations, and there's some history that leads up to that point, you may be able to say that the intention of the legislation can be seen from X, Y, Z, and this is therefore what it means because there are two choices. What it doesn't mean is they'll say, we have written this, but in fact we meant something else. If they meant something else, they need to go back and amend it so it says what they mean. In the same document, they say, it remains a responsibility of individual businesses to ensure compliance with the law and to all requirements related to foodstuffs concerned, such as labeling, ingredients, sale and promotion, etc., as stipulated in the relevant regulations published in terms of the Foodstuffs Cosmetic Disinfectants Act. So they're making it very clear. They've issued these guidelines because people were sending them lots and lots of questions. What they're saying is, this is not the law. You must still comply with the law. And to comply with the law, go read the law. You can read the guidelines, but at the end of the day, you must then go look at the law and see if this makes sense, what we are saying. Okay, so I've just picked out of the air some of the guidelines that have come up in the past, which I've had issues with or questions, etc. And I just thought, let me just highlight a few of their guidelines. By the way, don't get me wrong, I don't disagree with all the guidelines. In fact, I think a lot of the guidelines are quite good. I also think that the guidelines can play to your advantage in some cases. Because where the department has stated this is their interpretation of the regulation, if I tell you, but it doesn't mean that, in fact, what it means is worse for you, and you then choose to apply the guideline, it will be very difficult for them to prosecute you. Okay, so here's an example. This regulation prohibits all advertisements and promotional practices for designated products with the exception of complementary foods. Complementary foods can still be advertised and promoted to the general public, but not through healthcare personnel or health establishments. It's correct. It's a guideline. It makes sense. It's the right thing to say. Then they say the following practices are not prohibited for complementary foods. Can be promoted and sold at a baby expo. Competitions with prizes. The prizes may not include a designated product, but you can still have a competition which has a different prize, a toy, or whatever the case might be. Tie-in sales, e.g., R1 airtime with the purchase of a jar, but a tie-in sale may not include a designated product. You can have a special display in retail outlets, and you can have advertisements about the availability of the product and the price of the product. So these are good guidelines on what you can do, for example, for complementary foods. If a company produces products with the same brand name as designated products, can promotional products be given at events? And in fact, it's something that I mentioned a bit earlier. You may make different product ranges, only one of which falls within what we're discussing today. And if so the question is, if you have products with the same brand name as the designated products, can the promotional products be given away at events, for example, t-shirts, caps, etc.? If they only carry the brand name, does this exclusion only cover products in one? And the answer there was no. Any event for the general public must not feature a brand name of a product associated with the products listed in sub-regulation 7.1. So they address this question. Now, do I agree with them? I don't think they've thought of all the possible permutations of this. as I say, for example, that you may in fact sell different product lines, some of which are unrelated. I'm not saying that you have a t-shirt company. I'm saying that you have different products which could be sold, and signage could be up for those products, even though it's the same brand. Can industry still provide financial contributions to professional associations, such as the Nursing Council, ADSA, South African Pediatric Association, etc.? Under the regulations, there's no specific ban on industry providing financial contributions to professional associations. However, these financial contributions sponsorships should not be specific to a meeting addressing infant and young child nutrition, should not be used to promote any designated product through healthcare personnel and health establishments, are prohibited for healthcare personnel working in infant and young child nutrition. In addition, Regulation 7.5 stipulates that industry or anyone on their behalf may not produce, distribute, or present educational information related to infant and young child nutrition. And then they also refer you to the HPCSA guidelines on over-servicing, perverse incentives, and related matters. To be honest, I don't know these guidelines. I'm sure that they mean something to someone. But they address about providing financial contributions to professional associations. Of course, that means you're allowed to give it to them. It doesn't mean necessarily that you have to or that they have to accept it. Can financial contributions and sponsorships be made to healthcare providers who work with adults, e.g. to attend an event that focuses on adult renal disease? The answer is yes. Regulations do not prohibit sponsorships to healthcare providers to attend an event that addresses adult nutrition, etc. But bear in mind what I said earlier, in this meeting, that child nutrition could come up. But as long as that wasn't the intention, it wasn't on the program, it wouldn't be a problem. Can healthcare personnel not working in infant and young child nutrition receive sponsorship financial contributions from a manufacturer, distributor, retailer, and their representative of designated products? There's no specific ban on industry providing financial contributions or sponsorships to healthcare personnel not working in that field to attend conference unrelated to designated products or infant and young child nutrition. Do sponsorships for conferences need to be anonymous, or can conference organizers state which companies provided the sponsorship? Conference organizers may state which companies provide sponsorship of the conference itself. What the regulators intend to avoid is creating any conflicts of interest or perverse incentives for individual healthcare personnel. Consequently, pooled resources are mandated for industry sponsorship of healthcare personnel. The main rationale underpinning Regulation 7.2J is that companies should not be allowed to use sponsorship of healthcare personnel working in infant and young child nutrition as a means of creating brand loyalty or as a marketing tactic. It is important to note that conferences should not be used as platforms to promote and advertise designated products. Now, that is, of course, very clear from the regulation, and as well as how the money has to be pooled and who then allocates the pool from the sponsorship money. Can manufacturers have an exhibition stand at healthcare professional conferences to impart information of a technical and scientific nature relating to designated products? So the answer is yes. Manufacturers of designated products may have an exhibition stand at conferences and are allowed to provide technical and scientific material that relates to the designated products, but not information on infant and young child nutrition in general. Promotional practices as competitions with prizes or any other incentives with gifts and displays of designated products referred to in Regulation 7.1 are prohibited, and that display samples are seen as promotional practice and therefore it would not be permitted. I still think it leaves the question of what is technical scientific nature open. May manufacturers or distributors still continue establishing educational meetings related to infant and young children nutrition, from which HCPs may gain CPD points? And these meetings involve the company requesting an independent healthcare professional to educate others. So you bring someone in and you ask him to do the education. A small honorarium would be given to the speaker to compensate for the time taken. Now, this was also one of the questions raised, asked for me to address, and I do address it further later. But their answer was no, according to Regulation 7.5. No manufacturer, distributor, retailer, importer on behalf of the aforementioned shall produce, distribute, and present educational information relating to infant and young child nutrition. However, they may establish education meetings for CPD points if it is unrelated to infant and young child nutrition, e.g. adult nutrition. You'll see that when I answer this question, I actually approach it differently, and you'll see when we get to that question and the answer. Does Regulation 7.5 create a blanket ban where no manufacturers, distributors, retailers, or importers of any commercial product, whether infant and young child products or not, may produce, distribute, present information on infant and young child nutrition? Yes. In terms of this regulation, it creates a blanket ban. No manufacturers, distributors, retailers, or importers may produce, distribute, present information on infant and young child nutrition. This is not limited to companies that produce designated products. The intent of this provision is to ensure that education information that is not product related, but rather information that intends to impart knowledge on infant and young child nutrition is not company sponsored or promotional in any way. It's important to note that healthcare personnel may not sell, etc., etc. Okay, so let's have a look at 7.5, because 7.5 is an interesting one. No manufacturer, distributor, retailer, importer, or person on behalf of the aforementioned shall produce, distribute, etc., etc. So, but is it a manufacturer, distributor, retailer, importer in the context of this regulation? My view is that when because of this regulation being relating to food for infants and young children, the manufacturer, distributor, retailer, importer must surely relate to this. If I'm an importer of BMW motor cars, why would I be limited from relating information on infant and young children nutrition? Of course, the question then arises is, so, but why would you? So if I interpret this that it's not any importer, distributor, manufacturer, etc., the question still arises then, so why would such a person provide information about a specific product which is not theirs? So although the law doesn't specifically prohibit it, it will probably flow from the underlying relationship. Remember the definition of distributor, it referred to agent, it referred to someone acting on your behalf. So you can't front someone to do this. But should someone out of their own goodness of their heart decide to start promoting your product, but they're not related to you in any way, I think it would be very difficult to stop them. What does technical aspects in reference to Regulation 11.3 mean? So Regulation 11 stipulates a person, manufacturer, or distributor may provide technical scientific material to a healthcare provider and set down conditions which the material needs to be complied with. And here we need to just think very carefully, because I think this can be interpreted in several ways. The term technical aspects is not defined in the regulation. This relates to scientific and factual matters, because that is stated in the regulation. Regarding the compositional issues, nutritional information table and list of ingredients. Now, let's just go and look at 11.3, because I think they are extending what 11.3 says. It says it relates only to technical, such information or material is restricted to current scientific and factual matters and is in accordance with the relevant regulations under the Act, which does not mean the same as. This relates to scientific and factual matters regarding the compositional issues. Nutritional information table, list of ingredients, indication of use, suggested. So they are conflating different topics. Yeah. Directions for preparation, methods of use, storage instructions, and shelf life of the designated product. It should be noted that definitions, regulations define healthcare provider as any person providing healthcare services and or social services in terms of any law. Therefore, persons who are not registered, such as a community health worker, are not included. Now, truthfully, if I hadn't read this guideline, I wouldn't have thought of this last point, that these community health workers are in fact not registered in terms of any law. So it's these guidelines, although they don't have the power of law, I think they are useful. One must read them, and then you must go look at the law and see to what extent are the guidelines correct and to what extent have they used poetic license in interpreting the guidelines. Okay, so guidelines are now behind us. Let's look at the Agricultural Product Standards Act of 1993. Now, I'm not going to go into any great depth here, really. It's just 1 or 2 slides. But what I do want to mention is obviously new dairy regulations. I've dealt with problems relating to follow-up formula and complementary foods. And I see there's a question in one of the questions that came in last night relates to this as well. We have new dairy regulations. Regulations relating to the classification, packing, and marking of dairy products, which came out, if I remember correctly, in November last year. And then it says, no person shall sell a dairy product or an imitation dairy product in the Republic of South Africa unless such product is classified and presented for sale according to the class referred to in Regulations 3 and 23, and unless such product complies with the relevant standards specified in 42. And there's a whole lot of other things. I think it goes down to G or H. But point 2 is very important. The prohibition set out in Sub-Regulation 1 shall not apply to the sale of a dairy product or an imitation dairy product. There is an infant formula and a follow-up formula. Please note, no reference to complementary food. There is an infant formula and a follow-up formula, as defined in the regulations published under the FCD Act, in other words, R991. So the Department of Agriculture is deferring to R991 when a product wouldn't fit into one of its categories. In other words, it doesn't fit into one of the definitions, but it fits into a definition under R991. The difficulty is if you have a product that doesn't fit into into the dairy regulations, and at the same time is not an infant or a follow-up formula, you have a problem. And I'll talk about that when we get to that question. So that was all about the dairy regulations. I really didn't want to get into a huge discussion of the dairy regulations. Let's talk about the Advertising Regulatory Board. So the Advertising Standards Authority of South Africa was an independent entity organized and financed by members of the Marketing Communications of South Africa. Its purpose was to manage South Africa's voluntary self-regulatory system of advertising. And it was then replaced by the Advertising Regulatory Board when the ASA went under. By the way, I see I didn't add the last line in, I meant to say that. So, and they have an Appendix E to their code, advertising of breast milk substitutes, baby feeding bottles, and teats. And I actually want to jump out of the presentation and just show you that it's here. So I hope you can all see now on your screens Appendix E of the ARB. Can you see it, Nazneen? Can you nod?
We can see it.
Okay, great. Okay, so you'll see.
Although I think you might want to just increase your font size, Janusz.
Okay, like that?
Better. Yeah, that's it.
Okay, so this is Appendix E, which deals with advertising and marking, etc. Then it says, let's not talk about the breast milk substitutes. Let's talk about baby feeding bottles and teats. So it says, product information for feeding bottles and teats should not be in contravention of the spirit of Clause 1 above, and in particular should in advertising not be in a form which is prejudicial to breastfeeding, must carry a statement orally and in print not smaller than the main body copy of the advertisement, stressing the necessity for good cleansing of the feeding bottles and teats. For product packaging, it says, It should bear on the label or as a pack insert with the product, including samples and bulk packs, the following instructions in at least one of the official languages. That the feeding bottle and teat should be rinsed in clean cold water and then brushed with clean hot soapy water. That the teat should be rubbed inside and outside with salt before sterilizing. Now, I don't recall seeing this in R991, but certainly it's in the ARB requirements for product packaging and advertising of these products. Potentially, a competitor could lodge a competitor complaint against a company that's not doing this. Hopefully, if they're doing it, because you'll all remember the saying, people in glass houses shouldn't throw stones. And then secondly, when it comes to advertising, there's this requirement here about the size of font and how big the message must be, etc., etc. So, yeah, this is important. It's in the ARB appendix, and potentially it could be a problem from a self-regulatory point of view if a consumer lodged a complaint, if a competitor lodged a complaint. Okay, let me stop sharing this. Let me go back to the presentation. I think is it that one? Oh, was it that one? So what's very important is that the ARB does not deal with regulatory non-compliance complaints. So if there's a regulatory issue, somebody is not complying with the Act or the regulations, a complaint will have to go to the Department of Health. The ARB, if they receive a complaint about regulatory, you could in fact spend a lot of time and then it eventually gets rejected, and the basis of the rejection will be, if it's a regulatory matter, take it to the regulator. Very important to understand that. I mentioned very briefly, much earlier today, the issue of that besides the ARB, there's a second body called the MCA, Marketing Code Authority, which is a non-profit, self-regulatory body with voluntary membership drawn from manufacturers of medicines, medical devices, and in vitro diagnostics. The MCA's Code of Marketing Practice lays down ethical rules for the marketing of medicines by its members. Medicines must be taken very broadly. I've been to a couple of their meetings. At one stage, I served on the legal panel. Come to think of it, I may still be on the legal panel. Medicines must be taken very broadly, and health products fall under medicines. So if your product can potentially be seen as a health product because of the medicinal claims you're making or any other basis, it could in fact fall under the Marketing Code Authority as well. Marketing Code Authority works on a different principle than the Advertising Regulatory Board, because the members of the Marketing Code Authority are in fact technical experts in the field. They can in fact entertain technically complicated complaints and rule on them, whereas the ARB will not. Then moving on from self-regulatory, I also wanted to raise the issues of when one considers policy making and decisions regarding sponsorships, things like that, which are covered to a large extent by R991, but which are not always clear. So I found the Unicef guidance on sponsorships, which in turn refers to the WHO recommendations, and it says, so core to the selection of potential Unicef donors is a series of suitability criteria, which could include programmatic affinity, corporate social responsibility, and the demonstrated interest in advancing Unicef's mandate and work. Then they say, integral to their due diligence before they accept a sponsorship or donation is also a series of exclusionary criteria referring to industry sectors and business practices which are considered misaligned with UNICEF mandate or its partnering values. And they then list some of the things that they consider to be misaligned with UNICEF. One is, WHO recommends exclusive breastfeeding up to 6 months, then with complementary foods up to 24 months and beyond. breast milk substitute manufacturers violating the International Code on Marketing of Breast Milk Substitutes and baby bottles of foods marketed in a way that violate the code. And then if there's a reputational aspect such as media public coverage, reach and status of controversies. Now the last one can seem to be very unfair because you can be involved in a controversy not because you're wrong, but because you are being assailed by ignoramuses. You know, one sees a lot of this on social media that the people who shout the most about topics of public interest know very little about the science of those topics. But somebody like the Unicef says, well, we have a reputation to protect. We can't be seen to be involved in something which is contentious or controversial. They don't say we can be seen as long as we're on the right side of the debate if it's controversial. So it's very important to understand. So those are approaches that are being taken by a body like UNICEF. And then I found this interesting article which said UNICEF stepped away from a Royal College of Pediatrics and Child Health conference in Egypt when it found out at the last minute that the conference was sponsored by Nestle, Nutricia, and Danone. And I think some of the people on the line today are from some of those companies. You probably know about this. As reported in the press, more than 100 medics and 13 health groups wrote to the Royal College to urge them to drop the sponsorship. So it's interesting. So when one considers we have the law, which is R991, and what it allows and doesn't allow, but beyond that is the bigger picture of what companies taking part in this sphere will or won't accept for other reasons. So let's talk about professional bodies, because professional bodies clearly are the ones that most likely to apply this type of principle. So first of all, we need to understand professional bodies are by and large non-profit organizations by and for members. The concept of a non-profit organization is very important because it's in fact set out in tax law, and it defines that it can never be that any member of the NPO benefits financially from the proceedings of the NPO. Everything that's being done by the NPO must be for the benefit and to advance the profession. So the constitution and rules are designed to advance the profession, grow and protect reputation of the profession, be answerable only to members. I say that maybe that last one, some do have in fact provision that someone can lodge a complaint because there's a code of conduct. So maybe answerable only to members is not strictly true. If somebody was to lodge a complaint against the code of conduct, I suppose that you would be answerable to your members because your peers would judge you whether you are complying with the code. Okay. But professional bodies have to act within confines of law, as long as these are not discriminatory in terms of justification provisions of Section 36 of the Constitution. So a professional body certainly can set its own rules, can say, we dietitians, we only accept people who are registered dietitians as members. We are food scientists. We only accept people that have a degree in food science or engineering degree related to food science or whatever the case might be. It would be very difficult for somebody with none of those qualifications to try and argue that, but it's their constitutional right to join, even though they're not in that profession. And a professional body can then set its own non-discriminatory standards, but obviously also within the ambit of competition law. So you can't set standards which would result in an uncompetitive environment. And as I say, one can refer to the World Health Organization, UNICEF, or even the International Association for guidance on how do policies and procedures get set to ensure that the reputation of the profession is upheld in a potentially controversial sector of the market. And finally, moving on to the last topic before the questions, which is constitutional right to free speech. So there's a case of British American Tobacco South Africa versus Minister of Health. You'll all know, long before lockdown, when all cigarettes were banned, except for the illegal smuggled ones, the question came up, which is a limitation on free speech reasonable and justifiable in an open and democratic society based on human dignity, equality, and freedom, taking into account relevant factors, including the nature of the right, the nature and extent of the limitation, and the effect of the limitation. Now, the reason this question came up was because in the tobacco, I've forgotten, can you believe it? I've forgotten the name of the act. But anyway, it's a Tobacco Control Act, I think. It specifically prohibits making contact with anyone in relation to promoting cigarettes, etc. So the court upheld to limiting and preventing the spread of tobacco usage among South Africans, which is a policy which was initiated in response to the global concern regarding the extremely harmful effects of tobacco on those who consumed it and those who exposed to secondary smoke. So the court ruled that that trounced the right of free commercial speech by British American Tobacco due to public health concerns. So if you weigh up the right of British American Tobacco to be allowed to contact people, we're not talking here about putting up a billboard and advertising on the side of the highway. This was some way where they used social media to make direct contact with smokers and then try to promote their brand to that person. So we already know that the courts have spoken on this point. So what is the constitutionality of R991 and its effect on commercial speech? It has so many prohibitions in it. So one has to balance the right of manufacturers or distributors of infant formulae, bottled teats, and certain feeding cups to communicate information about their products to consumers, the rights of consumers to receive such information, because obviously there are various rights here. There's a right to say something, I have a right to hear something, and then the commitment of government of South Africa to promote breastfeeding and improve the health of children. Now, these are seen as opposites. Are they opposites? IFA probably doesn't see them as opposites, but they can be seen as opposites. Is the right to communicate the opposite of promoting breastfeeding and improving the health of children? So the rights of the child, in particular the right to the enjoyment of the highest attainable standard of health and the best interests, are a compelling reason to limit the rights to free speech. A country like South Africa leans heavily on the WHO. So if the WHO view supports their view or creates their view that promoting breastfeeding is the opposite of allowing you to communicate about your products to consumers, then that is the starting point of this debate. Sorry. Yeah. So in my view, I think that R991's limitations on free speech are justifiable. No one has challenged it so far, but I think it is in fact justifiable. As in the British American Tobacco case, it is clear that if this were to go to court, the court would say that public health would be more important than the right to be able to market products to the public. Okay, so that was the last slide, let's call it, of the substantive presentation. Now I'm going to get to the questions. But before we get to the questions, I first need to say a big disclaimer. And this is really important because I don't want to be misunderstood what we're about to do now. I don't want people running out taking commercial decisions which cost them lots of money and then coming back and saying, but you told us we can do this, or you told us we can ignore this or ignore that. So the questions which follow were provided for the webinar as interesting topics to be presented, and the discussion which follows should not be taken as a legal opinion and is based on the very limited information provided. If there's ever a field where the devil lies in the detail, it comes to products like these. You have to know everything about the product. You have to have the packaging in front of you. You have to have the product composition information in front of you, your marketing plan, before one can give a legal opinion in this particular topic. So in law, it's all about the specific facts. And if you need a legal opinion, then you need to properly brief legal counsel, and then a legal opinion can be provided. Do not act on the views expressed herein. Very important. With your specific product, because your specific concern may have a scintilla of difference from what I am discussing. To you, it may seem similar, but legally it may be different. There may be more than one way to interpret any law, and there may be different views than those which follow. Now, to illustrate this point, I don't know how many of you know what the law reports are. The law reports are books which are published. They used to be published on paper, now of course they're all electronic. And all important cases, and there are hundreds and hundreds of them, thousands of them every year, get published in bundles. And if you go into a lawyer's office, you'll find behind them on the bookshelf, you'll see rows and rows of leather-bound books called the law reports. And a client once asked, and he said, what do you think is my chance of winning this case? And I said to the client, I said, you see those law reports on the shelf? Well, every case has two parties. Each party thought they were going to win before they started the case. Otherwise, they wouldn't have started the case. So your chances are about 50-50. Now, what does it mean? It means that if you have two lawyers in a room discussing the same subject matter and presuming they both understand the subject matter, they may still have different views on how it is to be interpreted. Okay, I'm not going to belabor that anymore. I've made it clear. Please don't just jump and take action based on what I'm saying. You do need to consider your specific facts. Let's start with the first question. So, first question was worded this way: sponsorship of private dietitians, HCPs, to attend conferences where infant and young child, I think I should say nutrition, a feeding, partial or sole is being discussed, e.g. ALLSA conference and the allergy management of pediatric patients. A pool of funds is not an option for private hospitals because they are not employed by the hospital and they are not familiar with the process of seeking permission via the Director General of Health. Okay, clearly this was written a while ago. I think we're on our third DG already since then. I don't think anyone has inquired via the Director General, whether private or government. So that's how the question, I didn't write that question, I copied it and pasted it so that you could see what the question was. Okay. My answer is in red. The understanding is incorrect. The pool of funds is not from the private hospitals, but it is the pool of funds for Congress organizers of the conference. So the hospital itself doesn't have to know how to deal with the pool of funds. Whoever it is that wants to sponsor dietitians, healthcare professionals, etc., to attend this allergy management of pediatric patients conference must simply donate the money to the Congress organizers without precondition. And the Congress organizers, once they know how much money they have, will then, from a hat or in some other way, select the number of delegates that the amount of money they were gifted or sponsored with will cover. So I hope that answers this question. So it's not the hospital that's going to have a pool of funds and then have to try and work out who to send. The way to do it is to donate the money to the Congress organizers, and they will then do the selection in accordance with Regulation 7.2J. Next question, sponsorship of research. What about disease-related malnutrition in infants and young children? Regulation 7.2H is clear. This cannot be done unless prior approval has been obtained by the Director General or a person designated on his or her behalf. That's how the regulation is written. If we go look at 7.2H, zip, 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 zip. Research grants or any other financial assistance relating to infant or young children nutrition provided to healthcare personnel working in a health establishment or healthcare personnel linked to a health establishment unless prior approval has been obtained by the Director General. So if you weren't providing it to healthcare personnel working in a health establishment or healthcare personnel linked to a health establishment, then you could probably do it. But you wouldn't be able to do it if it related to one of those two categories. Let's quickly just zip back to there. So this question didn't say sponsorship of research by whom. When I read this question, I thought, oh, it's going to be a healthcare professional established, linked to a health establishment. But I think if you had to sponsor this research, say at the university, by an academic who is not linked to a healthcare establishment, in fact, it should be possible. So that's important. This answer presumes that the research is being done by a healthcare professional linked to a health establishment. Can we pay an honorarium for speakers at events where pediatrics and nutrition, disease-related, is a topic of discussion? Only the guidelines specify that it's not allowed. The guideline is not legal. To a large extent, that's what we were saying. But the answer is not clear. It depends on who the speaker is. Is the speaker a medical doctor? Then the regulations may or may not apply. Let's have a look at 7I and 7J. It's not my dog. I don't have a dog. Okay. So it's prohibited to make financial contributions or sponsorship to healthcare personnel working in infant and young child nutrition. So is this person that's going to be speaking working in infant and young child nutrition, or is that person a university professor from the Department of Food Science and Technology, for example, which is not related to infant and young child nutrition? Well, it's not a healthcare personnel working in infant and young child nutrition. The second point is J, sponsorship of meetings, and this of course can be interpreted very broadly. Targeting healthcare personnel where infant and young child nutrition is a sole or partial topic, unless the contribution is made into a pool of funds, where the problem would maybe arise is there would be no specific way to use the pool of funds to pay for a particular speaker, because how would they be selected by a fair and transparent process? Although it's possible, if you had 2 or 3 speakers to choose from, and the Congress organizers picked one of those speakers in a transparent way and paid the honorarium from the pool of money given to them for the Congress, not given to them to specifically give to anybody. So I think that it is possible, but it will be fairly tricky. One will have to work it out quite carefully so that you're not in contravention of that. I don't think you could simply on a one-to-one basis call a person and say, we need you to speak, we will pay you so much. That would be a problem. I think the event organizers would have to follow that other procedures set out in the regulations. Sorry, set out in 7I and J. Can a company sponsor funding for a breast milk bank in a hospital, as long as there's no company branding or recognition of sponsorship? So, Regulation 7.2G applies here. So, donation to or distribution of any equipment. Now, I presume a breast milk bank is type of equipment. It's some sort of storage equipment, etc., including the building, renovation, or maintenance of a health establishment bearing the company name or logo. Now, in the question, it's quite clear. There's no company branding or recognition of sponsorship. So as soon as there's no company name or logo, 7.2G won't apply, because it only applies when there's that logo, which is specifically intended for providing care to infants, young children. But regardless if every other word here is true, if it doesn't bear the company name or logo, then 7.2G won't apply. And therefore, the answer to this question, I think you can, as long as there's no company branding or recognition of the sponsorship.
Janusz, before you move on, it was about the remuneration of a healthcare professional to speak at a congress, for example.
I'll go one back.
Yeah, so there were 2 questions on this point. One is that the remuneration for work done by the HCP is not sponsoring per se, nor financial assistance as defined by Art 991. That's one point on that. And then the second one was paying a speaker to talk is not a sponsorship. Can you please clarify?
Well, you see, it is a sponsorship because somebody has to pay for the speaker to talk. So is it being generated from the from the entry fee for the Congress, and then the person is being paid, or how is the person being paid? If one of the companies that make the product's money is being applied to pay for that speaker, then in fact they are sponsoring that speaker. Whether they are sponsoring the cake stand at tea or paying for the speaker, they are giving an amount of money so that the meeting can in fact take place. So I do think that in fact it can be a problem. Let's have a look at 7I and J again. So the first one is financial contributions. Let's forget all sponsorship. Let's just read financial contributions to healthcare personnel working in infant and child nutrition. So regardless whether it's a congress or not, or a speaking event or not, if the healthcare personnel who's going to be speaking in fact works in infant and young child nutrition, then you can't make a financial contribution to them, because that's what this says. That's the way it's written. J says sponsorship of meetings targeting healthcare professionals. Now this one, let's go back to J again, because without the speaker, there is no meeting. So by paying for the speaker, you are sponsoring the meeting. I can't see how else you would interpret that. Otherwise, where is the money for paying the speaker coming from? You know, that's why if it's a congress where people pay to go, I attend conferences where some of them are very expensive. They can cost $2,000 to attend a conference. And they have highly paid speakers. Those speakers are not being paid because someone is sponsoring them. They are being paid from the entrance fee. And if they're being paid from the entrance fee, none of this applies. But if they are being paid from money specifically given by one of the companies which is affected by these regulations, so that the talk can take place, that can only be a sponsorship, or at the very least a financial contribution. Because without that, the person would not have spoken. I don't know if that answers your question, Nazim.
So there was just a retort on that, saying that the definition of sponsorship in R991 is actually not referring to payment.
Yeah, but this thing goes further. It says financial contribution or sponsorship. If you look at on the screen at I, financial contributions or sponsorship. So one or the other. You can have a financial contribution if you want to argue it's not a sponsorship. It's still a financial contribution.
So you'll interpret it accordingly. I mean, it would still be the financial transaction.
Yeah.
So paying for the actual presentation, and you're saying it would not be allowed then.
But if you and I were just talking about organizing the conference, you would say, will you contribute towards this person's speaking fee? Yes, I would. There, it's a financial contribution. I mean, I don't know how else you would frame it, because that's what it is. You are giving money so that this person will speak.
Okay, noted.
But let's quickly have a look. I think I had the definition of sponsorship right at the beginning. I hope I did. Let's have a look. There we go. Sponsorship means any financial or in-kind assistance. So it's there. It's in the definition as well. Any financial or in-kind assistance to a person, group, or activity. I'm sponsoring Professor so-and-so to talk at your activity. I'm giving money so that there will be an activity. It's a sponsorship. I'm not sure which definition the person is talking about when they say that the definition is different.
So then just on the back of that, will you then not be able to pay a healthcare professional for consultancy opportunities?
So we've got to be careful. I'll be honest, I don't know about the HPCSA. I'm sure they also have rules about when you can pay a doctor and things like that. So I'm just going to be careful. I'm not speaking about that. One would have to look into that specifically. I haven't looked into it. I haven't thought about it. I don't know those rules off the top of my head. But certainly a company, if you look at the definition of promote, okay, a company that is in this market cannot pay this healthcare professional for a speaking opportunity. What I think they could do, that's why I said there are various possibilities here. And let me just go back to 7J, 71J. Oh, sorry. No, not 71J. What is it? 72J. Sorry, there we go. So there are two possibilities. The one is that the money gets given to a third-party organizer. There's an organizer of conferences. They are conference organizers. And the sponsorship is made to them. We want you to organize a speaking event. Because it says you can do that. Is made into a pool of funds for Congress organizers. And those Congress organizers will then use that pool of money to invite delegates as well as speakers. And from that pool of money, they would then give the delegate or the speaker his honorarium. But they would have to follow a fair and transparent process to be followed in the election and sponsoring of delegates to attend such events. The speaker is then also a delegate. He's just a speaking delegate. So I think there are ways to do it, but I don't think it can be directly from a manufacturer to the speaker. Come and speak, here's the check. I think that could potentially be contravention of definition of sponsorship, definition of financial contribution.
Janusz, what would happen in the event of the IFA, for example, where we have already got a pool of money from the different subscriptions, obviously from the member companies, and then we could arrange for a speaker by using the pool of money?
Oh, no, you can definitely be the Congress organizers. Congress organizer isn't some special body out there. Anybody can decide they're a Congress organizer, and regrettably in South Africa, there are many that claim to be Congress organizers. So IFA definitely can say, we are organizing this Congress, we are collecting money for this Congress, and then you distribute it, you invite attendees, etc. The question isn't that. The question is you need to follow this process. So you probably have to have 2 or 3 potential speakers, which generally I assume you always do anyway, because you don't know if the one person is going to agree or not. And based on your list, you would then approach them and you would say, we would like you to come. We have chosen you to come and address our Congress or our meeting. And we are prepared to give you an honorarium for doing that. But that's coming out of the pool. That's not coming, you wouldn't say to that person, and this money came from company X. That person mustn't know who the money came from.
Okay, then just, we still discussing the same 7 to I and J.
Yes.
If the honorarium is not linked to enticing a person to use or purchase a designated product.
Yes.
Because obviously the regulation there that we're talking about is linked to promoting designated products. But if the speaker doesn't promote designated products, will it still apply then?
Let's quickly have a look. Promotional practices or devices in the respect of the products listed in regulation. The only products that are excluded are complementary foods. Because if you look at 7.1, it's everything except complementary foods, if I'm understanding your question correctly. So the promotional practices that are not allowed, no person shall undertake or participate in any promotional practice or device advertising in respect of. So as long as the promotional, so these are the prohibited. So let's just be clear, 2 is simply unpacking of 1. The broadest is this prohibition. No person shall undertake or participate. So the doctor, whoever you're going to get themselves could be contravening 7.1, not just the company giving the sponsorship. No person shall undertake or participate in any promotional practice in respect of. If you can cross each one of those off, then you're not contravening regulation 7. Or 7.1 anyway, or 7.2. Because 7.2 is actually a subset of 7.1. It's not a separate thing. Does that make sense, what I've just said?
Yeah, I think we note that.
Yeah. But the other thing to note is that by getting someone to speak who doesn't understand this regulation, you could actually get them into trouble in terms of R991. Okay, let's try and go back to where we were.
But Janusz, let's just unpack that question properly then. So if
which question? Oh, the honorarium one.
Yeah, the honorarium one. So if this honorarium is not linked to the purchase or, you know, enticing them to actually relate to a designated product, and if the speaker does not promote designated products, would this 7.2 INJ still apply?
No. So just so we're absolutely clear, I'm going to pull it up on the screen again. I just so there's no misunderstanding. So if the speaker is not undertaking or participating in the promotional practice related to any of those, we're not talking about any specific manufacturer's infant formula. In general, he's not promoting or advocating infant formula, follow-up formula, any of these things. They're speaking about something completely different. They speak about, as you say, the physiological condition, but don't then say, and therefore you should give them a infant formula for special dietary or medical purposes. Because once they say that, you've got a problem.
Okay. Then on the basis of what you just mentioned about the conditions, etc. So, you know, given that on 7.2J, nutrition is not defined in R991, what would happen should there be presentations about the condition, like the physiology that you mentioned now? So, for example, allergy and colic, etc. What would happen then if a manufacturer then sponsored a meeting?
No, so, okay, we're just going to be careful, because as soon as it's a manufacturer, we're going to have a problem, because that's what they make. They make one of these things. C, maybe, infant or follow-up formula for special dietary or medical purposes. They make it. So if they are sponsoring the meeting, it would be very difficult to say that they are not undertaking or participating in any promotional practice or device advertising in respect of infant or follow-up formula for special dietary or medical purposes. And they specifically say in 7.2A and B, sale devices, what they are. Let's quickly have a look. No, that's not the one. Okay, but that's not the public attending. So this the meeting would be for healthcare professionals. Am I correct?
Yes, correct. So instead of, you know, we understand that we cannot talk about nutrition or, you know, feeding, etc. But what would happen if the session actually had the topic about addressing colic or addressing allergies or something else more physiological rather than nutrition or feeding?
No, so
discuss. There's no reference to the actual infant formula, follow-up formula, etc.
No, so you're correct that no person, as soon as you're not promoting or device advertising any of these things, if I got on the screen now, then you're not in contravention of Regulation 7. What one then has to be careful of is the use of the company's branding and logo. Okay, that E talks about the general public, the brand name of a product when used at any event for the general public. So it's not for the general public.
Specifically for healthcare professionals.
Yeah, advertisements in written publications. Okay, that's also not donation or distribution. No, that's also not it. Research grants, financial. But that's also just in terms of that other, so that's not fine. That's fine. That's fine. I want to see if no person shall sell. Let's look at 7.3. No person shall sell, promote, or advertise. No, through healthcare personnel, so that's not relevant. Okay, one has got to be careful of 7.4 in doing what you've just said. So as long as you avoid 7.4 as well. And 7.5 you have to be careful of. No manufacturer, distributor, retailer, importer, or person on behalf of the aforementioned shall produce, distribute, or present education information relating to infant and young child nutrition. So again, you'd have to really avoid the whole issue of nutrition.
Mm-hmm.
But the way that I can see, I don't see that it's a problem to present on the actual medical topic, if you want to call it that. But not, so you can identify the problem, but you can't provide the answer, if that makes sense.
Yeah, I think it's clear, you know, we need to understand that as long as it's not related to the actual product and it's not supporting in terms of a solution, but it's actually unpacking the condition and the
Yes.
science, there shouldn't be a problem.
But what one has to be very careful of is often, and I'll be honest, I haven't been to a presentation on one of these products, but I've been to presentations at many companies, and the presentation comes from overseas. And somebody just presents it and they don't understand our particular legal requirements. And they will have on every slide a logo and a product name. So all the content of the slide speaks to identifying some or other intestinal condition or whatever. In fact, they are promoting the FSMP on every single slide. So I'm just saying, you just got to be very careful of that.
Okay, noted. Then I have a couple of other questions, I think on this very topic. So one is, what happens if you sponsor a surgeon or a medical professional not working in pediatrics to attend a congress where infant nutrition will be discussed as part of that program? Would that be allowed?
So let's just go. I'm just going to be very careful. I'm not speaking from the HPCSA's perspective. I don't know what a surgeon is or is not allowed to speak on in terms of their rules, if I'm just clear on that. Because
I think
I
it's more
don't
to
know.
attend rather than speak. Sorry for interrupting you there. So basically you take a company and they would then sponsor the surgeon that's not working in pediatrics to go to a congress that's actually got topics on infant nutrition. So would that be
No, it's a problem. So let's just start looking at 7.1. 7.1 starts with no person, doesn't say no healthcare professional working in infant nutrition. It says no person shall undertake or participate in any promotional practice relating to these items. So whether he's working in infant nutrition, whether he's something else, if the result is that he's promoting any of these things, it's a no-no. And then if we go to 7.5, no manufacturer, distributor, retailer, importer, or person on behalf of the aforementioned shall produce, distribute, or present education information relating to infant and young child nutrition. So now we would have to look very carefully. Is this person speaking on behalf of the sponsor? And are they presenting educational information relating to infant and young child nutrition? If the answer is yes, 7.5 prohibits it.
Now, I think it's more about attending rather than presenting. I think that's really the clarification point needed. So this person that's being sponsored just attends the conference without having to present anything.
Now, okay, but he's sponsored to attend.
Correct.
Then you got to deal with 7J. Let's just look at this thing. Maybe I'm wrong. I'm going to just read this again. Targeting healthcare personnel. No. So if he's a healthcare personnel, if you look at 7J, so this is an exact copy. I didn't paraphrase it. This is copied from the regulation. I'm very glad I did that. Because it says sponsorship of meetings targeting healthcare personnel. Doesn't say healthcare personnel working in child and infant nutrition. It says targeting healthcare personnel, and then where infant and young child nutrition is a sole or partial topic. So you can't sponsor a healthcare personnel to attend such a congress without following the rule 72J.
Okay. I think we're going to move on to other questions.
Makes sense. I think it makes, yeah. It's not limited to healthcare personnel in that division, in that field. It's any healthcare personnel if the Congress is about infant and young child nutrition or includes a topic. Okay, yes, next question.
Okay, I'm going to move on to Reg 7.5. It's still linked to the promotion of designated products. So is it allowed to distribute educational information, whether related to infant and young child nutrition or not, if it does not promote those products?
No manufacturer, distributor, retailer on behalf of the aforementioned shall produce. Relating to is very broad, you know. Relating to infant and young child nutrition is regardless whether it's promoting anything. Relating to is such a big topic. Everything else falls under that umbrella. No manufacturer. No, I don't think it's only if it's promotional. Eh? So 7.4 deals with promotes. We must remember 7.4 and 7.5 have to be different, because you wouldn't have the same thing twice. So 7.4 says, no manufacturer, distributor, retailer, importer, shall produce or distribute any educational material on infant and young child feeding. There they limited to that promotes any product referred to in sub-regulation 7.1. But 7.5 is broader than 7.4. 7.5 simply says relating to infant and young child nutrition. Truly, I don't understand why they needed 7.4 and 7.5, because in fact 7.5 is so broad it includes 7.4. 7.5 relating to is regardless whether it promotes or not. It simply relates to it. And young child nutrition must also be so broad that it makes it very difficult to understand how anything could be excluded. Okay.
So then we are saying that it's not allowed.
No, I don't see that it's allowed, because that 7.5 prohibition is so broad that it actually excludes everything, not just promotion.
So the retort on that is that shouldn't 7.5 be read in conjunction with 7.1? No,
because 7.5 doesn't refer to 7.1. 7.4 refers to 7.1. Sorry, I keep flipping backwards and forwards. I hope I'm not making people seasick. So 7.4 specifically says any products referred to in sub-regulation 7.1. 7.5 doesn't say that. If they had intended 7.1 to be limited by 7.1, if they had intended 7.5 to be limited by 7.1, they would have said referred to in sub-regulation 7.1 at the end, and they didn't. So when one interprets law, those are the rules you apply. You say, if things are written differently, they must be written differently for a reason. There's never a presumption in law that they forgot it, but it must have meant the same.
Okay, so just to ask two more questions on the same topic then.
So I mustn't zip up and down.
We covered quite a bit about using the product logo, for example, on presentations, etc. What happens if it's a bigger company that obviously has a company logo, and we use the company logo, not the brand itself?
And that's why I actually put up this definition early on in the presentation, because I thought it's really important. Brand name means a trademark or name given by a manufacturer or distributor to a designated product or range of designated products and include brand logos. Now, this is not well written, but it can pose a problem to companies that don't distinguish between different product categories under one brand, because the brand logo could very well be the same for designated and non-designated products. But the way brand name is written, it specifically says includes brand logos. Doesn't say includes brand logos of designated products. So they could be very difficult and try and insist that if the logo on designated and non-designated products is the same, you're not allowed to use that logo in the context of the infant food regulations. But maybe explain to me what the problem is, because I'm trying to understand. Look, if it's a non-designated product.
So for example, so my company, Hahn, makes both designated and non-designated products. And I've got a presentation now, you know, or a piece of, I don't know, a referral paper, etc. And instead of using the designated products logo, I use my bigger logo of Hahn dietitian. Will that be allowed?
But you mean in the, but your products which are in the market, so the trademark or name given by a manufacturer or distributor to a designated product or a range of designated products, it's your Hahn range of the Hahn company.
Correct.
Is that what you're saying?
That's what I'm saying.
Okay. So, okay, and then your question is, how do you use the logo?
Can I use Hahn, because that's my company, versus this is the Hahn range of infant products.
Okay, but what is your concern about the prohibition of the use of the brand name?
Because it's a designated product.
Okay. No. So I would interpret this. Look, you've got to give this a realistic interpretation. If a product has a specific, it's the Hahn range of designated products within the Hahn company, which makes thousands of other products. I wouldn't think there's a problem to simply use the Hahn logo generically as your company. But if you don't have this differentiation with your within your company, in other words, all your products, designated and undesignated, are only known as the Hahn products, you've got a problem. Because the best interpretation I can give you in terms of this definition of brand name is that if you have a separate name for your range of designated products, then that would be the brand name for the range of designated products. But if you don't, if you're only using the same brand name for everything, then you snook it.
Okay, I think that's clear. I trusted that
question. I've got to tell you that I can still see somebody at the Directorate Nutrition arguing about that, but I think that one has to give it a realistic interpretation which works commercially and practically and so on. I'm not sure that they necessarily understood what we've just discussed now when they wrote this.
Janusz, just on that, we're still on Regulation 7 there, of course, but can we use the name of a product when it is not for the general public? So, for example, in a pharmacy, etc.
Well, I mean, the product has its name. So, I mean, in a pharmacy, the product name is used. I don't understand the question, sorry.
7.2, and I think it's E.
The brand name of a product, when used, no, but it's not an event. The pharmacy is not an event. So it's fine. But there is also a provision about selling product in health establishments. Hang on a second. There was a provision, I read it earlier somewhere, which said that where you're selling a product in a health establishment, but you can't market it. I quickly want to see, give me a second. It was somewhere here. I remember reading it. Sorry, I just, for the life of me, can't remember where it was. It was, there was a specific provision for, it's probably further. Ah, sorry, there we go. B, notwithstanding an institutional pharmacy in a private health establishment may, that's only if it's a pharmacy, I think, in a hospital, sorry. So that's slightly different. But in any event, okay, so in a hospital, it's different than a normal pharmacy, say, in a mall. No, but let's look at 7.3. No person shall sell, promote, or advertise any designated product yeah, but that's in a health establishment. Okay, now that's fine. That's fine. Sorry, a bit off track there, but that's fine. Yep. I think E is only if you've got an event, so don't worry about E. That's only if you've got some sort of show or something like that.
All right. I'm going to take the questions as they came up onto the screen while you were busy presenting. Yes. So we might have to go back to the beginning, and then I don't know if we might have to come back to 7, but just indulge me.
But Nazneen, shouldn't we finish the questions that people sent in yesterday?
You still have a few there.
Yes, yes.
Right. Just to keep real in terms of time, we've got 15 minutes to 1 o'clock. I don't know if anybody wants to still stay on if we haven't finished, or if they'd log off. So let's just have a look. Up to you.
Let me quickly zip through these ones then. Okay, can a company sponsor funding for equipment such as shelving in a store? Well, that was the same as the breast milk bank, and it's fine as long as there's no logos and no branding, so that's okay. Okay, so the person sent in this very interesting question. I think it's important, is the one about the sachets with the yogurt and the heat treatment and whether it's in the regulation and so on. It's a very long question. But it effectively deals with complementary foods, which would be considered a composite dairy product, and must it be labeled in terms of those regulations as well? And the real problem being is that you can't call it yogurt because it's heat treated. So if sold as a dairy product, then the definition of composite dairy product applies and to be considered a composite dairy product. But in terms of the dairy regulations, yogurt may not be subjected to heat treatment after fermentation. They would have to get a direction from DAF, as the dairy regs only deal with infant formula and follow-up formula, not these pouches specifically. And then we went through regulation 2.2 a little bit earlier. It says that the prohibitions, in other words, this whole issue of not heat treating and the compositions and so on, shall not apply to the sale of a dairy product or an imitation dairy product that is an infant formula and a follow-up formula. Now, my suggestion, in fact, is just reformulate it as a follow-up formula, because a follow-up formula is a type of complementary food. You find my interpretation of definition of complementary food and definition of follow-up formula is correct. So if you can reformulate your product to fit in the definition of a follow-up formula, then you can use regulation 2.2's exemption, and then you wouldn't have to worry about the question that was asked. But if you don't do that, then unfortunately you're not exempted from the regulation, and you would need to get a dispensation or something from the Department of Agriculture, or alternatively ask them to add it to the next list of amendments so that you can actually make the product. Okay, the next one, in terms of indicating different products in a product range specifically to the different stage level of baby's growth, with indicating different teats available depending on the child's age on the back of bottles packaging, and also including this information on a banner on your website be considered product information, educational information, or advertising. Where do you draw the line between whether this is product information for the customer, which is permitted in the regulation, or educational advertising, which isn't? Now, the world wouldn't need lawyers if you could draw the line everywhere and say, when you do this, it's this, when you do that, it's that. And it often comes down to interpretation in a particular set of circumstances. But let me give you my interpretation. So, if a consumer needs to know the size of the different teats in order to be able to make a decision on which one to buy, this is then product information. It's like children's clothing, 6 to 12 months, 12 to 24 months, you've got to know what size to buy. Regarding the banner, I think it depends on how they want to display the information on the banner on the website. Are they advertising that their teats are based on a child's age, or are they informing the consumer that there are teats for different child's ages? There is a difference. So unfortunately, the answer is not clear. It depends on how you're doing it. There's no one-size-fits-all answer, but I hope that from the answer you can see where we're going within distinguishing between advertising and providing information. R991 regulation states that special displays such as gondolas displaying designated products is prohibited. However, if the baby products aisle is visible at the entrance of a store due to the planogram of the store, would this be seen in contravention of R991? I actually did speak to it while I was doing the presentation on the regulations. In terms of regulations, special displays are mentioned when it comes to promoting a product. See the definition of promote. It deals with a method or scheme of enticing a person to purchase a product. And then it's got a whole definition of promote. I won't read it. Let me give you my conclusion. I do not think that this is aimed at baby products that are visible at the entrance due to the planogram of the store. Intention is the key. It's problematic because if you got challenged on it, you would have to be able to show that you did this not because you wanted to display the products in a prominent place, but because that is the layout of the store. It's easier for people pushing prams to get to it, or whatever the rationale is that you have. Okay, this one is very close to my heart. Previously, when anti-colic was discussed at the IFA, it was not considered a medical condition. What is your take on this and your legal opinion, etc.? Now, my daughter had colic until she was 2. I can't remember the first 2 years of my life because she literally didn't sleep a single night. So I sympathize with anyone whose children have colic, but I'm not a doctor. And I know when we took her to doctors, every doctor had a different opinion on what the situation was. And interestingly enough, eventually, one of the baby foods that we were told to take seemed to stop the colic. Now, I don't know if it would have stopped anyway, but it did. Anyway, okay, so I'm not a doctor. I don't know if it's a medical condition, but I would be wary of placing such a claim on a product because it's maybe a medicinal claim. And if it's a medicinal claim, you're going to end up being, at the very least, a complementary foodstuff, a complementary medicine, maybe even a registrable medicine. And as I said earlier, this is not a forum for legal opinions, but as a discussion topic. Colic is normally excessive crying for long periods, etc. But it can mask a serious medical condition, as there are health conditions that can look like colic. If you're going to put such a claim on, you'd also need to put a warning that parents should seek medical assistance if the crying continues. Then we've got the question that came regarding the bottles, etc., and the logo of the manufacturer. It's a very, very long question, so I won't read it in the interest of time. But it came down to, is the bottle a container or is the bottle in a container? And I think that's really what this whole question comes down to. And Regulation 6.3, a label, package, or container of a feeding bottle. So for the purpose of this, the bottle is not considered the container. This is the container of the feeding bottle, which shall not show any graphic representation other than for illustrating, cleaning, and sterilizing the logo of the manufacturer or distributor. And container includes anything in which the food is served, etc. But if you look at this definition of container, it doesn't fit into this regulation because here they're talking about container of a feeding bottle. Food is not served in the container in which the feeding bottle or teat or feeding cup comes. So it's a different context. Can the feeding bottle or cup itself have a graphic representation? I'm now referring to the guideline because, in fact, I agree with what the guideline said. And the answer is yes. Regulation 6.3 prohibits any graphic representation other than for illustrating cleaning and sterilization and the logo of the manufacturer or the distributor on the label, package, or container of a feeding bottle. The intention is to ensure the carer can see if the bottle and the feeding cup are thoroughly cleaned, to ensure gradings are easily visible, etc., etc. So I agree with the answer in the guideline. Okay, now we can go on to your other questions, Nazneen.
Okay, so I've got, can a company not manufacturing designated products sponsor a healthcare professional to a meeting where infant and young child nutrition is being discussed? So it's a company not manufacturing designated products at all, but they are sponsoring a healthcare professional to a infant, young child nutrition.
So there are two aspects here. The one is from the point of view of the actual person attending, the healthcare professional. The other one is from the perspective of the person who is sponsoring. So they're just going to attend. They're not going to speak. Am I correct?
That's correct.
Okay. So 7.5 won't be relevant here. Let's go back to. No, so in terms of sponsoring of someone to attend a meeting, if they are a healthcare professional, okay, let me go one step back. Sorry, before I give you the wrong advice. Okay, no person shall undertake or participate. So this is not limited to a company that makes any of the products, any promotional practice in respect of. Okay, but I'm trying to picture how that would work and why that would be. But let's say a pharmaceutical company that makes normal ethical pharmaceuticals, scheduled pharmaceuticals. It makes, for lack of a better term, drugs, blood pressure medication, whatever. And they now want to sponsor some people so they can go to a congress because they need to collect CPD points. Then clearly they don't fall foul of 7.1 because they are not undertaking or participating in a in a promotional practice in respect of those, as long as the Congress isn't also dealing with those. Because the participating is a very broad term. The health professional would probably be participating. And although they wouldn't be the one doing the promotion, if the Congress did promote these products, there could be a difficulty there from the point of view of the actual person attending rather than the person that's sponsoring. And then if we look at sponsorship, so now the company wants to know, can they sponsor? Sponsorship of meeting targeting healthcare personnel. Let's go back. No person. So no, but just reading this quickly, it's an interesting question. So that company is not promoting, it's not what they sell or what they don't sell. They are not promoting any of they're not in this business at all, in fact. Which means 7.2J wouldn't apply to them. No, just as we sit here, I think that would be fine. So a company, a bicycle manufacturer, decides to sponsor some doctors who happen to be part of a cycling club to attend a congress like this. I think it would be fine.
Okay, thank you. I'm going to move on to the next one.
Yeah.
So the question relates to 7.4 and 5.
The last one.
Are they not in contradiction with Regulation 11? Can you please clarify what we can present and discuss with healthcare professionals when we engage with them? I think in terms of technical claims, etc.
Yeah. So that's a very difficult one. That's not a 1-minute answer, because you saw their guidelines or whatever, and they definitely try to distinguish between technical scientific material, and as I said when I was dealing with that one aspect of the guideline, they view it as being very limited in scope. It's really how you use the product. relates only to technical aspects and methods for use of the designated product, excludes any promotion of the designated product in any manner. Now, I'm not sure how that conflicts with 7.5. Oh, I see what you're saying. Okay, I understand. So this is saying no manufacturer, etc., shall present educational information relating to infant and young child nutrition, and 11 says may provide scientific material. You see, they are distinguishing between it's almost like that question about the difference between providing information and advertising. This is a difference between providing scientific material and educational material. So educational information is probably seen as going a lot further than just simply the very narrow technical scientific material, which is restricted to current scientific and factual matters. You're really providing almost like the package insert type information, material safety data sheet type of information. That's what this is, as opposed to the educational. And you'd have to, the way we interpret law, where two sections of one regulation appear to contradict each other, you have to find a way to interpret them so they can be read together. And because this is the narrower one, in my view, you would have to restrict what you do to this. Sorry, is there anything else?
No, I've got a couple of other questions on all of this.
Yeah.
So again, I'm gonna now go from the top to the bottom in terms of the questions that were asked. So the first one was relating to gifts. How does it apply to companies who have both designated and non-designated products?
Yeah, so there was this weird thing here. I think we looked at it. Okay, so gifts was obviously defined very, very broadly. In 7, they refer to promotional items, such as stationery, t-shirts, other items of clothing, etc. So, in fact, I tried to distinguish that when I was presenting. As I said, if you're a company that makes household utensils, but at the same time you make bottles and teats and things, then the one is a non-designated product, the other is a designated product. So you should be able to give the non-designated product as a promotional item, which is, but it's not made as a promotional item, if you know what I'm saying. It's an actual product that you make. You didn't make it for the purposes of promotion, because then it's not strictly speaking a promotional item, because there was a provision here about I don't know what, I had it somewhere in my mind. I've forgotten now where it was. In some circumstances you can, but in others you can't. I'm just trying to think which it was now, where it was. Sale devices. Because 7.2a says you can't give any incentives or gifts. So maybe, what is it they want to do? Maybe just run it past me again. Sorry, I can't see it in front of my, I can't read it. So just say it to me again.
So for example, a company, like you said, makes stationery and then also makes infant formula, for example.